Please, Your Lordship. Lordship, with regard to item number 29, my lord, we need some accommodation, my lord. My lord, actually, his matter was fixed on 21st of July.
Twenty-first.
Yes, my lord.
Item 21.
29.
29. Huh?
Three cases are taken together, 27, 28.
Perhaps that's why it has come.
Yes,
My lord, 27 and 28 may be taken today, my lord. But my lord, item number 29 may be taken on 21st of July, my lord.
Tagging is by way of some judicial order.
My lord, because due to same FIR, my lord.
But it is tagging is due to some judicial order.
My lord.
You'll have to wait. Renew the prayer when the matter is called.
My lord. Bless.
Daily list item 1 for withdrawal.
Please, my lord. My lord, as per instruction of the petitioner lordship, I seek permission to withdraw this case, lordship.
Okay. You are Mr.
A. Datta, lordship.
A. Datta.
Yes, lordship. A. Datta.
File your memo of appearance. Your name is not there in the Vakalatama.
No, lordship. I have already lost.
No, we don't know. You give a mention your memo of appearance and give your bar.
Last lordship, may I please, lordship. Last one, 7/7, I have filed a Ukalat.
It's not here. You give your memo of appearance along with your bar council registration number.
And lordship, other learned council, lordship, give NOC, lordship.
Can you understand what I am saying?
Yes, lord.
What did you follow, please?
Lordship, as per instruction of the other council, lordship, withdraw.
Please tell me what did I say? If you don't have patience to listen to us, you're not getting any order. What did I tell you? Did I say no? I told you to give a memo appearance and give your bar council registration number. You'll have to give that.
Yes, lordship. Lordship, I have to file Ukalat number. That Ukalat number.
List after the vacations are over on a date to be fixed by the registry.
Item 2.
I'll just make a mention. The one Mr. A. Datta, learned counsel, appeared and prayed for withdrawal of the proceedings. So, however, his Vakalatama is not on record. He was asked to give a memo of appearance and disclose therein the bar council registration number, which he has refused to do. So, accordingly, the prayer is rejected, and let the matter be listed after the ensuing vacation. After this vacation, on a date to be fixed by the registry.
May I please, lordship, that matter may be fixed on 13.
We are not doing anything.
Lordship.
We told you once you don't accept us, what we are saying, we're not getting the desired order.
Item 2.
Unless I'm praying for a short Passover. I'm praying for a short Passover, my lords.
Just a moment.
For today.
Yeah, no, for a time being, my lords.
Just a moment. Okay, after some time.
Obligation, my lords.
Item 3.
Item 3.
May I please, your lordship. The 483 lordship, please, the petitioner are who were arrested on 35/2026 lordship, as on the 41 days behind the bar lordship. Allegation under section 108 and 3 subsection 5 of BNS lordship. Allegation is that the wife of the petition number 1 lordship, who has committed suicide by
We'll
hanging
have to call
herself.
for the case diary.
Lordship.
with the case diary released on when
This is a Boramari PS plus. 28 July 20. আচ্ছা বলুন।
20. Item 4.
60 days February के
Item 4.
This is 60 days offense maybe 60 days offense then student pay will be over.
It's a case of attempt to the abatement of suicide. Without the case diary, will not be able to.
Then prior that lordship on minor and then 16 minor. আচ্ছা বলছি।
Yes.
Smith, please, your lordship. Hey, FIR is at the page 14, lordship. The gist of the allegation is on 9/6, on some secret information, one search was made on body of the Rekubur Rahman, 6 grams of heroin.
NDPS. We'll call for the case diary.
No, lordship, I am just give me 1 minute time, lordship. According to spot interrogation was made on his disclosure, one Mafidul Hassem, who was also arrested, lordship. Subsequently, if you lordship go to the page 18 and 17, lordship, forwarding report, lordship. I am Rishi Mali. I am not the FIR named accused, lordship here.
But this is under
No.
No,
NDPS.
this is drugs, NDPS.
At page 18, lordship, the grounds of arrest, lordship. May I be permitted to read, lordship? During investigation of Morigaon PS 8726, the arrested accused person, namely Rekubur Rahman, disclosed in their voluntary statement that they have been regularly purchasing narcotic drugs from Rishi Mali. I was arrested on 28/6. Search was made on 9/6. I was arrested only on the basis of a statement of accused Rekubur.
Paragraph 6. Those your
Lordship. So,
antecedents.
those are the cases I have mentioned disclosed,
No,
lordship.
that's okay. but-
It is in 23, lordship. I was a drug addict. In 23, I was a drug addict with a small quantity case, lordship. Subsequently, these two cases have been falsely implicated. I am facing trial, lordship, in these two cases of 24.
But still, in NDPS.
The
cases,
case diary is available,
case
lordship.
diary
in the court, lordship.
Available.
Yes, case diary is available, lordship. Case diary is available. lordship.
13. 30. Okay. We'll wait for some time.
Lordship.
Please wait for some time. Item 5.
Item 5 to PROCEEDINGS.
Yeah, please, your lordship. The POXO is there. Lordship, I am behind the bar for 34 days. Lordship, let a case diary be called for and notice me issue, lordship.
Let the case diary be called for. As per the in view of the nature of offense, issue notice on respond number 2, which is made returnable on
20 July.
20. 7/20/26. No, 20 you will not be able to serve. It is at Manipur, Bongaigaon.
Manipur.
This is POXO.
Also, it is also and also minor.
27/7/2026. The petitioner shall take steps in course of the day for service of notice on respond number 2. Post of the registry on receipt of the requisites shall hand it over to the office of the public prosecutor, Assam, for service on respond number 2 through the jurisdictional police station. Post of the officer in charge of the jurisdictional police station shall ensure return of the
Same apply.
service report
Same apply.
through the office of the public prosecutor, Assam. Next list on 20, 27/7/26.
Item number 12, AB, lordship. This is out of the same affair. Same
Same.
order may pass, lordship. And
Item
matter
number?
may be taken together. Item
12.
12.
Same order.
And matter may be taken together, lordship.
Same date. Item 7.
Public.
Item 6.
With the pleases, your lordship. Here, your lordship, this application filed under section 483 of BNSS. Your lordship, if I take you straightly towards the page 14 of annexure 1 FIR, I'd like to read it, your lordship. May I, your lordship?
Yes.
Your lordship, this was filed on dated 17/6/2026, your lordship. Respected sir, I, Hamidur Rahman, and
This has been in
admit-
use for some time. We will have the case call.
Here, your lordship, I am nowhere connected, your lordship, and if I take you to the annexure 2, your lordship, that is, I am your lordship, respondent number 1 to your lordship, but here, your lordship, I am nowhere connected in the said FIR, your lordship, and no, your lordship, no connection has been since, your lordship, though is in this, your lordship, FIR. So I'm praying for interim prayer, your lordship.
No.
Then your lordship, short date may be given, your lordship. Let the CD call for.
This has been in use for some time.
Yes, ma'am. People.
Bokhisto,
There were 3 incidents, one after the other.
Oh.
In different jurisdictions,
Yes.
same offense
Yes,
in
ma'am.
a span of very short dates.
In the FIR also it is clear, madam.
2/23 of 2026.
No, not that I won't remember the dates because I read the newspapers and then forget about it.
In several areas, madam. Yourself.
3 incidents
Yes,
in
But
gap
your
of
lordship,
1 week.
in the said FIR, I am nowhere connected, your
It's okay.
lordship.
FIR may not have. may
Nothing
not
has
be-
been seized from my position, your lordship. In that
May not
spot, in that very spot, your lordship, I am not there, your lordship.
May not be. That is why we have a very good apt definition. One is a person who does it, and one is called a mastermind.
Okay, your lordship, I have no issue, your
Right.
lordship. Let the CD call for your lordship.
That the case diary be produced on. This is from which place?
Bokhisto.
From system, madam.
Bokhisto. Then 21st you can produce it.
That's
Can it be on little bit earlier, your lordship, 15th?
15, madam. Perhaps it won't come, madam.
Oh, 21st is a holiday. 23rd.
Can it be a little bit earlier, your lordship? Since I'm nowhere connected, your lordship, 15, your lordship.
Okay.
15.
15.
I'm deeply obliged.
626. Item 7.
May please, Your Lordship. Here, my lord, FIR document finance page 11. It's start from case 12, my lord. May I read the FIR, please? So, my lord, kindly see, my lord, section charge, my lord. Except 74, my lord. All are billable in Nassar, my lord. And so far 74 is concerned, my lord, that is, my lord, outraging modesty, my lord. And in the FIR, my lord, the specific allegation, my lord, so far, my lord, outraging modesty is concerned, my lord. It alleged against, my lord, one Paplu Pang, Tulsi Pang, Jeripa Kaman, and Srimati Tutu Kaman, my lord. And Jeripa, some of the accused person, my lord, name in the FIR, my lord, against whom, my lord, outraging modesty is, my lord, alleged, my lord. move an application before this honorable court, my lord, and they were, my lord, granted interim bail, my lord. May for this letter, order, my lord. And accused before your lordship is, my lord, Harakanto Saingin. I was arrested on 16/6, my lord, and as on date, my lord, 33 days in custody, my lord. Jeripa Kaman, testimony, and so far petitioner is concerned, my lord, there is no allegation of, my lord, any outraging modesty, my lord.
You give them the protection then. They've already been protected.
He is the mastermind, my lord, said. Perhaps he is the mastermind.
But no allegation of, my lord, modesty. My lord.
But Mr. K. Bodwar and counsel for the petitioner and Mr. M.P. Goswami and ATP for the state. By this application under section 482 of the BNSS.
The 483, my lord.
It's a
Regular
bill.
Oh, regular bill, I'm sorry. 483 of the BNSS, the petitioner was taken into custody on 16/6/2026 in connection with Boginadi PS case number 61 of 2026 under section 329 within bracket 3 oblique 296 oblique 74 oblique 117 within bracket 2 of the BNS. Let's wait for regular bail. Next paragraph. Case of the petitioner is that he and along with others had the informant and others were constructing, making construction on the land which they claim to be community burial ground. And all being objected, as a counterblast, the FIR was lodged, alleging that the petitioner and others had assaulted the informant and her husband and stripped her clothes and outraged her modesty, and also vandalized the shop. And also made an attempt to set the shop on fire. Full stop. Next. Although the learned APP has objected to the grant of bail, considering the that the petitioner was taken into custody on 16/6/2026, further custodial interrogation of the petitioner may not be required, accordingly, court is inclined to release the to grant bail to the petitioner in this so and so on the following conditions. Next, it may be stated that other co-accused, three other co-accused were released on PRS bail by this court by order dated 26/6/2026, passed in AB 1477 of 2026. Next, bail applications is allowed and disposal.
There is an interim manner, not on interim.
They were interim bail. Interim bail.
Interim manner, it was fixed on 37.
CGM local government.
Item 8.
All right.
Actually, 483 regular bail application. In connection with this case,
Pardon me?
regular bail application, ma'am.
Yes.
In connection with this case, allegation under section under 318 subclause 4, ma'am. 316 subclause 2, 351 subclause 2, ma'am.
Is the FIR?
FIR elegant.
You have the case diary called for. Let the case diary be produced on 15.
Let's sort it.
No, sorry, 17. No, I'm making a mistake. Yes. 17, it can be confirmed. 17, 6/2026.
Always.
Item 9.
Next page. FIR, Lordship, page 15. Type copy.
So we'll have to issue notice.
Show is there, Lordship. After submitting the charge sheet, he has, after receiving the summon for, from the special judge, he is appeared before the special judge on the day the applicant was arrested. As because he has recorded his statement during the investigation, plus the police has released, but there is no bail application, bail order is attached in the charge sheet. So therefore, he was arrested in connection with the Sadgaon PS case number. Lordship, that was subsequently
But still,
registered as a
we have
special.
to call for, we have to give notice to the other side
Lordship,
under the PROCEEDINGS.
Lordship.
In view of the nature of offense alleged, issue notice on the respondent two, which is made returnable on, this is from which place?
Sadgaon.
Okay. Nineteen 6/2026. The petitioner shall take steps in course of the day for service of notice on respondent two. Of the registry on receipt of the requisites shall process the same and hand it over to the office of the public prosecutor, Assam, for service on the respondent by through the jurisdictional police station. Post of the officer in charge of the Sadgaon police station shall ensure that the service report is returned after service. Next para. That the case diary.
My lord, the search
Oh, the charge sheet has been.
Yes,
filed.
stamp is here, my lord.
You have a charge sheet.
Yes, my lord. Search
Copy
sheet is,
filed
my
here?
lord.
Charge sheet is page number
Page
20.
20, my lord.
20.
Yes, my lord.
But
My lord.
Mr. Bashir, this is if what is stated in page 25 and 26 is correct, then some administrative steps has to be taken.
For charge sheet.
No, sorry, 20, it starts from 24, relevant page. I am
My,
on page 24.
my lord.
It contained that. Then last two lines, the on page of the case record, it appears that no bail order is available in the case.
My lord.
You see, this has relevance. If you please come to page,
Yes, my lord. It is in 25/6, my lord. Then I can, page
Just-
31, my lord.
page 22, first paragraph.
My lord. Okay. Yes, my lord. That part is there, my lord. 180, my lord. Statement is recorded. He was interrogated.
No,
my
after
lord.
that last, yes, after that he was released by
Yes, my
service
lord.
notice.
Yes, my lord.
So once he is released,
My lord.
therefore now if you read this last line, two lines from 24 onwards,
Yes,
then the court has found that in the charge sheet, the date of arrest is there, but release on bail is not mentioned.
yes, my lord.
The other things are not there. No release orders are there.
Yes, my lord.
And then the court refers to the High Court notification 17,
Yes.
that this is what the direction was. So if this is not being complied with, then we think notice should be issued to the police.
No.
Because if there is no compliance, they have to be given training.
My lord. Yes,
This is a serious lapse there.
yes, my serious lapse.
Registry shall call for the scanned copy of the medical reports, or if any of the victim, from the Court of Special Judge, POCSO, Kamru Metro Gauhati, in connection with sessions within bracket special SPL, bracket post case number 117 of 2025. This is page 27. Next para. In view of the order dated 11/6/2026, passed by the learned special judge POCSO, Kamru Metro Gauhati, let a notice be issued to the Director General Police, Assam. So along with the notice, the registry shall annex and thereto a copy of final police report form within bracket annexure 2, order the order of the special judge POCSO Kamru Metro Gauhati dated 11/6/2026 within bracket annexure 3, as well as a copy of the notification number 17 dated 15/3/2024 to bring to the notice of the said authority that there has been non-compliance of the notification number 17 dated 15/3/2024. So that remedial steps can be taken by the said authority. Full stop. The above shall be compiled and handed over to the Office of the Public Prosecutor from Assam for onward transmission to the Office of the Director General Police, Assam. Next para, list on 19/6/2026.
A copy of the order may be perfect.
We'll give it to you. The registry shall process and give it to you for onward transmission to the Office of DGP. Oh, sir, I'm making a mistake.
19 Sundays.
The dates I'm making mistake. I'm still in June. It'll be 20 July.
27, madam. Obliged.
Item 10.
Deeply obliged. Disqualified.
May I please, Lordship? Well, this is a substituted case. The present petitioners are behind the bar for 110 days. In fact, Lordship, the allegation in the FIR is that FIR is Lordship kidnapping and murder. And the present petitioner have been arrested on the ground that they gave shelter to the offender who has committed the murder in their residence, Lordship. My lord, the police has submitted charge sheet, that is page 21. My lord, under section Lordship 142 and 3(5) against the petitioner number 1 and others, and against the petitioner number 2, Lordship 249.
Charge sheet has been filed.
Charge sheet, Lordship, page 21 on 17/6/2026, charge sheet is filed. Page 30 is the important, Lordship. Accordingly, last paragraph, Lordship. Upon careful consideration of the evidence collected during investigation, statement of witness recorded, technical evidence obtained, and other materials available on the record, I am satisfied that prima facie case has been established against the aforesaid accused person under the above mentioned provision of law. Accordingly, charge sheet is hereby submitted against accused Harun Rashid. He is the petitioner number 1, Lordship. Jamir Uddin, Raju Haq, and absconding accused Afsar Hussain Barbhuya, under section 142-33(5) BNS and against Sharifa Begum, Lordship, this is important. Sharifa Begum under section, she is petitioner number 249. So 249 is available, Lordship. So my prayer, Lordship, let the case diary be, case record may call for Lordship from the trial court. And so for the petitioner number 2, Lordship, she may be released on bail because the section 249 is a bailable offense, Lordship. Against that, Lordship, charge sheet is submitted against him. Two 49, Lordship.
It will be 1/4 of the longest term. Under 249C,
See,
you will have to call for the records, then can't bail. 249 may not be A, maybe also C.
A, B, C.
C is 1/4 of the
All
longest
are,
sentence.
Lordship,
Longest sentence can be life here.
all are available.
All are bailable.
Harboring an offender if offense is punishable with death. In that case, imprisonment
Yes, that
for
is
five.
bailable.
My lord,
249, then
My-
release her on bail.
my lord.
Okay. But Mr. M. Khan, learned counsel for the petitioner, and Mr. K. Boyshul, and APP for the state. Next. I'm filing this application under section 483 of the BNSS for the petitioners, namely so-and-so, who have been taken into custody on 22/3/2026 in connection with page 1 PRC number so-and-so, page 1 of the application under so-and-so are paying for bail. Next part. The scan copy of the case records be called for in respect of the petition number 1. Next para. In respect of the petition number 2, namely Sarifa, SARIFA, Sarifa Begum is concerned, she has been, as per the charge sheet number 55 dated 17/6/2026. Which is annexed as annexure 4 to this bail application, she has been charged of committing offense under section 249 BNS, which is bailable. So accordingly, in respect of the petitioner number 2, namely Sarifa Begum, court is inclined to release, to allow her to be released on bail. The usual conditions are there in the bail order. Bail of rupees 10,000 of with one surety of like amount for the satisfaction of the it will be before the district judge. committal proceeding has been concluded or not? It is before CGM or it is
CGM.
CGM, my lord.
CGM, Kassa.
the satisfaction of the Chief Judicial Magistrates, Silchar as well. Next paragraph. List on. Sir, when you call for the case diary, always say case diary or scanned copy.
TCR, TCR.
Case records or scanned copies. Sorry, only scanned copies of the case records. List on 22/7/2026.
Public.
11.
May I please, your lordship, the intermediate quantity lordship, all for the case diary lordship. For that we given lordship, then North Gauhati lordship,
6.
on 16 or 17 law.
You can get it 17th. The case diary is on 17/7/2026.
Triple.
Once you call for the case diary here, there's no one.
May I please, your lordship?
Yes.
I'm appearing for the petitioner, your lordship.
You call for the case diary.
Lordship, here I have a submission to be made, your lordship.
Yes.
In the page number 19, your lordship, you'll find an affidavit that is filed by the informant, and the advocate for the informant is also present, that the FIR has been filed by the informant under some misunderstanding, your lordship. And she is behind the bar since 31 days, and she is the mother of the victim, your lordship.
You can say because there's an allegation of the death by suicide.
Yes, lordship, this is the FIR filed by the uncle, and the uncle, under some hearsay of the people, has filed the FIR, and he has filed an affidavit herein, that due to some
No, that-
misunderstanding, yes.
It's a case of death. Misunderstanding. Even if there's a misunderstanding, it's a duty of the court to find out the truth.
Yes,
Yeah.
lordship, but she is the mother, your lordship. She has no involvement in this case, your lordship. If the case diary is called for, at least, your lordship, I pray for interim, your lordship.
This is not a solitary case where the parents of a victim are being charged for murder of their children. It's not the
Lordship
first
may call
case.
for the case diary, but lordship may give the interim, if your lordship may kindly allow. She's behind the bar in 31 days, 60 days is the statutory period, your lordship.
No.
May I please, your lordship?
Uh, Counsel for the petitioner, for the learned entity, as well as the learned counsel for the informant are present. Next, that the case diary along with the medical report of the deceased be produced on. Here also scan copies be produced on. This is from which place?
But this is from
Samuguri, Nagaon.
Samaguri. On 20 July.
Right.
Please find out. Basically, we need the medical report.
Yes,
The allegation is of torture,
my lord.
but
Item 13.
Obliged.
May I please? The pre-arrest daily flexion. I have not been named in the FIR. The prime accused and the sister of the prime.
just a moment. Mr. Bashir,
My lord,
you see, in the last matter,
my lord.
I think, Mr. Kumar, you are there.
Ma-
Last matter was a matter where the girl died of suicide,
Abatement decision.
and what is disturbing is that nowadays the children of young generation, they commit suicide at a drop of a hat.
You can't scold them even for
Recently-
studies.
Recently, I came across a news where where the child has passed, but not with first division marks, and committed suicide. So I think time has come where there should be collective effort of all the bars to have
Mental
some sort of
Mental health.
counseling for.
I know the pain of suicide, my lord, since your lordship is taken. I know how it's painful for a brother to carry the dead body of his own sister. My sister was a teacher of Delhi public school, big boy. She made the last call to me, and on that night she took her own life. She was educated, everything. I didn't realize that why she has committed suicide.
I'm extremely
Later on,
sorry
I came to
called
know.
you, but it turned out to
Later
be
on, I came to
painful.
know, your lordship, that when a girl thyroid is operated, the side effect is you enter into a depression. Then you have to consult a mental health expert, and you talk. I being an educated, I being a lawyer, my own sister being a teacher, we didn't knew it. So your lordship is right. That way we should have mental health, at least for the young lawyers and all, because there may be many pressure of the professional pressure. They stay here in a rented place, don't get enough money to survive in the city. So it's a good initiative. Your lordship can always put forward. I will also share it with the bar council members, my lord.
Bar council and bar associations. but
Bar association, bar council can also
Mm.
take up, my lord.
They can always help in this mental
Yes.
health.
Many young lives have been lost, my lord. Actually, you need the family support, and sometimes due to ignorance also, this happens, my lord.
Competitiveness.
Mm.
Because if a child commits suicide for not getting first division,
Yes.
I think the
When
amount
your
of-
lordship was taking up, I was sharing with my friend that I did a case in Bongaigaon. The newlywed wife, just after 6 months, committed suicide. I got the acquittal there, but still that question lingers in my mind, that who may have killed her? I may get an acquittal, whether it's the mother, the husband, or you. This answer always lingers, mother. We are deeply obliged, your lordship.
I'm sorry.
No, it's
I called
okay.
you to
Now
just-
I have, it happened in 2018 January. Now 5 years too, it was very painful for me to come with terms. But now I have, because I had an old mother who was around 80 plus, father was around 90 plus, and she was the most brilliant child of our house. So it was very difficult to comfort my parents that why such a brilliant girl has taken her own life. And that too, she was going to be the principal of DPS school, big boy. Probably around 5,000 students have studied her. Now also when I met her students in Calcutta and all, if they know that I am the brother of Madhurima ma'am, they just hug me and cry, madam. It's very painful, madam. I know the pain, madam.
I'm sorry to have relieved your pain.
No, it's okay. That's why I've said, because when you operate thyroid, the side effect is that you go into that negative thoughts come. Then you have to consult a psychiatrist, and they will give you medicine for 6 months. And you should not never leave a thyroid operated patient alone. Oblige, your lordship.
Yes, Mr. Verma.
My lord, I have not been named in the FIR, my lord.
Where's the FIR page?
FIR at page number 8, my lord. I am the sister of the prime accused person, my lord. That's why police is searching for me.
What happened, my lord? The wife of Durgeshwar Terang, who is my brother, my lord, his wife has eloped with the brother of the informant, my lord, and they have given shelter to them, my lord. And in search of them, my lord, his wife and the person Bisham in TP, my brother went to in search of them, my lord, in the house of the informant, and there was some scuffle happened, my lord. No, I was not present there, my lord, and as such, there is my name is not been named in the affair, my lord. The detail about the incident, my lord, page number 17, ground number 1, my lord. My brother has already been arrested, my lord. In the forwarding information.
You have to call for the case diary.
Right.
Because the incident is of 2 months back.
Right.
Still, till now, nobody has been arrested.
My lord, one Durgeshwar Terang, Rajan Terang, and one Vinod Terang, my lord. They have been arrested. And Vinod Terang and Durgeshwar Terang are my brothers, my lord. Because some family members are involved, my lord, that's why police is also searching me, my lord. But I never went there, my lord. I'm a married.
The case diary call. Let the case diary be produced on. This is from which place?
My lord,
Portfolio proposed, my lord. Carbian law.
207-2026.
My- 20.
Can it be on 21st, my lord?
Okay, 21st.
20.
Okay.
Item 14.
May I please, your lordship? The lordship will find the FIR, it starts from page 9, my lord. My lord, actually, what happened on the night,
Just a moment. Wait, page number?
page number 9, my lord. The type 11 portion, my lord.
Yes.
On the particular night, my lord, I admit that some scuffling took place in between the informant and the petitioner, my lord. But it was started from the side of the informant. Subsequently, my lord, he fell down over his motorcycle who was standing beside him on side stand and might have got some injury, my lord. Thereafter, he has filed this FIR, my lord. So, my lord, let the case diary be called for, and till then I may be protected, my lord. I will appear before the IU. My statement may be recorded, my lord.
No, no, because your PRS bail was rejected by the Sessions Court also. There has to be something.
Although it is alleged that the injury was caused with stone and hand, but it is a false allegation, my lord. He got injury.
Let the case diary along with medical report of the victim be produced on 207-2026. Injury report also.
Yes, ma'am.
15.
Deeply over.
Yeah, please, Your Lordship. My lord, here in this case, Lordship, allegation and counter allegation is there. Lordship, FIR against us is at page Lordship 7.
Here we call to the case diary.
My lord,
There's a
FIR against us is at page 7. Here it.
we call to the case diary. The case diary along with the injury report of the victim be produced from, this is from which place?
My lord, it is from Borpeta, my lord.
Borpeta,
Orbuk Police.
2006, 2020, 207, 2026. Scan copy, huh?
My
16.
16 Lordship, the FIR Lordship, may I, Lordship, to your Lordship attention, the vernacular part, Lordship, page 15. This is absolutely a false case, Lordship, has been initiated. Lordship, page 15 is the, 16 is the vernacular. The Lordship may kindly peruse that FIR, Lordship. It's a type copy.
We'll have the case diary called for.
Only to recover the money, Lordship. It's a application FIR has been done. There is no date, not a single date has been mentioned that this date or that date to the incident was taken place, Lordship.
Whatever way, but allegations are serious.
Right.
The case diary along with medical report of the victim be produced on 22/7/2026.
Obliged.
17.
Made please, Your Lordship.
Yes, Mr. Bora.
The PRS bail application, my lord. Petitioner is a government Gaubura, my lord. In lot number 9, Nis Silabanda, Gaon Sotia, my lord. When FIR was filed, page 14, my lord, Your Lordship.
Abetment to suicide.
Yes, my lord. My only allegation, my lord. Page 14. CLM, just my lord. Even with the ground, may I read this FIR, my lord, Your Lordship?
Yes.
With due respect, I beg to state that I, Rajit Soika, is a resident of Pasigaon. I would like to inform you that my wife occasionally talks to Sri Vishnu Das, son of late Bapuram Das of Sengalimara, on the phone in spirit of friendship. However, Vishnu's wife suspected that my wife has an illicit relationship with Vishnu. Vishnu's wife currently stays at her mother's house in Dekasu. On the evening 4/6/2026, at around 6 p.m., Vishnu's mother-in-law called my wife and invited her to their house, discuss something, threatening to involve the police if she did not go. The next day, on 5/6/2020, my wife went to Dekasu with her mother at 11 a.m. Upon reaching their house, my wife and her mother saw that Gaon Pradhan and several other people were gathered there. After we arrived, Vishnu's wife, mother-in-law, and sister-in-law. After we arrived, Vishnu's wife, mother-in-law, and sister-in-law attempted to beat my wife. Even with the Gaon Pradhan present, where did they get the right to attempt to assault her? Therefore, Gaon Pradhan is entirely responsible for this, my lord. This is the Your Lordship vernacular, my lord, page 18, Lordship. My lord, গাঁৱৰ গাঁও প্ৰধান থাকোতে সিহঁতে মাৰিবলৈ খেদি অহাৰ অধিকাৰ ক'ত পালে? সেইবাবে গাঁও প্ৰধান হ'ব. Just my allegation is that part. And the actual fact, Your Lordship, I have already narrated as per instruction, my lord, para 5, my lord. Actually not in that, my lord. And thereafter, my lord, circle officer inquired the matter, my lord, as a Gaubura, my lord, Gau Pradhan, my lord. And a report was also submitted, my lord, that there is a, I have no any, my lord. May I read my para 5, my lord?
We've read it.
That the petitioner respectfully begs to state that the actual fact of the case is that one Sri Pankaj Nath and the petitioner is a neighbor to each other, residing at Dekasu village under so-and-so. The daughter of Pankaj Nath, namely Srimati Madhusmita Das Devi, married to one Vishnu Das of the Sengamara village. Sotia. Sri Pankaj Nath is the fourth stage of cancer patient. As a responsible neighbor, the petitioner always about the Pankaj Nath's illness. On 5/6/2008 around 11:30, petitioner's wife informed him that some hue and cry situation has been arising at Pankaj Nath's house, and in a good faith request to him to go there, as they said Pankaj Nath is a serious condition. Upon reaching at the house of Sri Pankaj Nath, petitioner saw that Pankaj Nath's married daughter shouted to two unknown ladies who were present in their house at the time. Petitioner, as a Gau Pradhan, requested all of them not to make such situation and directed them to leave that place and not to make such type of situation in future. Accordingly, all of them left the place. Sri Pankaj Nath left the place of Pankaj Nath. After inquiry, it has come to knowledge of the petitioner that 3 days back, the daughter of Sri Pankaj Nath, namely Madhusmita Das Devi, left her husband house with the help of Sotia police, as there was a cruelty between her husband and namely Vishnu Das for the cause of suspected illicit relationship between her husband and Vishnu Das with the victim, namely Rumi Soika. This is the actual fact, my lord.
Something has happened. There was a what you call media trial,
Media trial, yes, my lord.
and somebody committed suicide.
And my lord, the circle officer, my lord, inquired the matter and sending it. Please may kindly see page 20. This is the circle officer.
Because he is currently absconding and therefore no communication.
Yes, my lord, the report is page 22, my lord. Does it say that this so-and-so, this said allegations are completely false, my lord? This inquiry report, my lord. And as a Gambra, I have no rule, my lord. Two ladies are, they were.
You don't
my
know
lord,
because you're the named accused for the.
Not, my lord, as a
commitment of
Gambra, my
suicide.
lord, I cannot, my lord, and I am, my lord, requested them not to do it, my lord. That and on the basis of my request, they are in left, my lord. And so, but that's
It's ultimately a suicide and you have been named.
not, but Gaur, but that main, my lord, my lord, daughter of the said not my lord was arrested, my lord. So, my lord, at this stage, my lord, I may be protected, my lord, as a Gaur Pradhan, my lord. I have no rule, my lord. Because of two ladies, they are already, they are, her husband and that, my lord, this is some relation thereby they are, I have no knowledge at the time, my lord, after going due to hue and cry, as a neighbor, I am going to that, my lord. And I am requested them not to do it, my lord.
But
And
you're the
therefore,
named accused. You can't have it. You have to call for the case diary.
in the meantime, my lord, I
Let
may
the
be
case diary be produced. This is from which place?
in
Mr.
short.
Bora?
Jamuguri,
Jamuguri, my lord.
Jamguri.
My lord.
Can you get it by 17th?
17th.
17th, 7/2026. Scan copy. Huh?
I may be protected, my lord, just my lord, because
Since you're
of
the
that.
named accused.
Name it is there, my lord. Only because of that you are there. Why you not prevent, my lord? My lord, as a Gambra, I am limited, my lord. There, both her lady. I am the, my lord, male cannot, my lord, going to, my lord, there, my lord. They, my lord,
Can't tell you. They have
my lord, at least, my
know
lord,
the
I may be
allegation.
protected as a Gambra, my lord. Otherwise, my lord, my
No.
family, my lord, if I am arrested, my lord, I think that, my lord, as a,
No.
my lord.
18.
Made, please, your lordship. My lord, this is a pre-arrears bail application. My lord, it has a history from 2020-24. The locality Suburi of my area, they initially in 2024, some person have uploaded a picture without my head, and that picture later on appeared to be fake. Then due to that complaint, I was suspended from my Gaon Pradhan post. Then I came before this honorable court. The honorable court in a writ petition directed for the fresh inquiry and to take up consequential action. Now, the people of that area thought that High Court has granted me the full reinstatement. Then they started again those, if someone invites me to a local function, they will go and threaten them that we have boycotted this house, we have made them Agoria, why you are going on that. The extent went to such an extent, my lord. I have a mother who is a stroke patient. And in the night, my lord, the people of the neighbors, some people of the neighbors, they will start throwing stones in my house. I have reached such a stage that, my lord, today I had to go to Central Mental Health Institute at Tezpur and to do a psychiatric evaluation because of the constant this excommunicated by my own people and due to some vested circle. Now, on the last occasion when there was a stone pelting in my house, I went to the concerned officials to lodge a complaint. Immediately on that day, they lodged a complaint that I have uploaded some obscene sentences or words in the my Facebook post. Immediately, I went to the police station. They seized my phone and they registered a case which is punishable under the IT Act for 5 years. So they did not issue me any notice. I went for 2 days without any notice. They seized my mobile. I cooperated. Now, my lord, because of this case, my lord, there is no woman also complaining. Now, because of this case, I think they are calling me again to the police station, but due to political pressure of some local leaders, I may be detained in custody. Your lordship may call for the case diary, but prima facie, my lord, at this stage, my lord, my custodial detention may not be required. All the sections are available except those IT sections, my lord, and it should be explicit sexual content to attack that number. There is no such things, and no woman has complained. These are the same people. I have annexed all the complaint. The same complaint of 2024, the same group. This time also it is the same group. After the order of the writ petition, it has aggravated, my lord. And I have a old mother, my lord, who is also a cardiac patient. They throw stones continuously at our house. I have a daughter. Now the situation has come to such a stage that we may have to leave that area, my lord. It may not be possible for us to live anymore in that area. I have just 2 bighas of land and a house. Maybe I have to dispose of because the hostility that we are facing there, my lord, it is not possible to live for us. But now, because of this case, my lord, I am before your lordship, my lord. I leave it to your lordship's wisdom, my lord. I have annexed even the mental health certificates, the prescription of the Tezpur Mental Institute at page 74, my lord. High Court order. And the High Court order is at page 759. They thought, my lord, ignorant people, they thought that High Court has reinstated me in the post of Gauhati.
What has happened in the inquiry?
Inquiry is still going on, my lord. It's still going on, and I was about to file a contempt petition against because not completion of the inquiry within the stipulated time. At this juncture, my lord, this FIR came, my lord. Because the authorities have not complied with the orders. So I was about to file a contempt petition against that order. Your lordship will see the order of this honorable court is at operative portion is at page 68.
The order.
Yes. It starts from 59 and
Read the order.
yes, ma'am.
Where is the FIR?
FIR, your lordship will find at the 33 type copy.
33.
33 is the translated copy. And vernacular also I have given a type copy, my lord, at page 35. My lord, nowadays we have started this initiative of giving the vernacular in also in type.
That is
Two of
good.
my juniors know the Assamese typing, so we have given it.
That is good because at
yes,
times we
ma'am.
can't read this.
Yes,
Page
ma'am.
40 is not readable.
Yes, my lord. So 35 is the original vernacular, but your lordship will find that those words were used by the Hadar Hompatak of that Hoikia Subri Namgha Unnayan Committee. And they were the same complainant at 2024 also. That the earlier time also they lost such complaint before the DC, my lord. Your lordship may look into the earlier complaint also at page 47, my lord. Page 47, if your lordship looks, your lordship will find that they have even attributed statement against my wife at that particular point of time, my lord. Well, we have become helpless, my lord. Now a situation has arisen that we have to sell our land and move out from that place, my lord. And this act communicated is although illegal, just like Tejoputra, but still, my lord, in some villages they do it. And it creates immense pressure on those people, my lord.
But the genesis of the problem is at page 45.
Yes, ma'am. I have seen, my lord. If your lordship looks at the page 45, the words that are used, I have asked that no, these are not used by me. He says that it is denied. Just like in 2000,
No, page 45 is something else.
yes, this is of 2024. 2024. What they have done, they have taken out my picture without the head at that particular time they lost when went to police to laws also. They could not, police did not take. They lost the FIR, this complaint before the deputy commissioner. And without any inquiry, we were suspended due to political intervention. I came before this honorable court interfered, asked them, they don't comply with the orders of the court. And we have also annexed the day on which the stone pelting was done. When that complaint was filed, then this counterblast FIR has been lost, my lord. Even, my lord, the complaints were not given. We had to apply this page 45, that complaint also. We had to apply it through RTA and we got it, my lord. And that's why we could annex those complaints in the writ petition also. And it is because these complaints were all bogus, my lord. That's why the Honorable High Court interfered, my lord, and asked the authorities, concerned authorities, to do the inquiry, my lord. No chance of respondents. I had appeared before the police twice in regard to this FIR. Right. I'll go again once more before the concerned police station and will cooperate with the investigation. You'll also will look into the case diary because I have already surrendered my mobile phone. They have taken it and no seizure list was given. I have made a specific statement.
Where is that statement?
Para 18, my lord. Page 18. Family is respectable. Even the daughter, I'm told, is a advocate in Teshpur. They said that father has become frustrated, my lord, because of this continuous stone pelting in the house at the night, my lord. And grandmother, she says that is sick, is a heart patient. We have given those documents also.
But having read paragraph 18,
Yes, my lord.
page 26 becomes very amusing.
Yes, my lord. And my lord, what has happened, my lord? Normally what I have seen, because my father used to joke, my lord, when my father was a Congress, at that time ASU boys used to throw stones at our house. Then my father will console my mother saying that Pushpa Brishti is coming, don't worry.
No, but this paragraph 18
Yes,
at page 26
Paragraph 18,
and page 26.
26, my lord. Yes. Immediately. Oh, yes, probably he has, 18 to keep a little, right? Knowledge will dwell.
But we can
Ye-
protect him.
yes,
In the FIR, that copy is not there. The offending material is not there at page 33, 33, 34, and the vernacular is at page 37. Copies are not enclosed. But Mr. B.D. Kumar, Learned Senior Counsel, assisted by Mr. P. Dole, Learned Counsel for the petitioner, and Mr. K. Boshar, and APP for the state. Apprehending arrest in connection with page 1 of the petition. Okay, case number so and so, under so and so. This application has been filed under section 482 of the BNSS, seeking pre-arrest bail. Expected the scan copy of the case diary be produced on when, Mr. Bashir?
Lordship, my lord, 24th, my lord.
24/7/2026.
Yes.
It's by the Learned Senior Counsel for the petitioner raised for interim bail, which is opposed by the Learned APP for the state. In view of the projection that the dispute between the petitioner and the informant and others
The submission will be into knowledge.
is
18 to knowledge violation. The knowledge of.
continuing from
Full question.
June 2024.
Knowledge নাই তো mobile to see space
Court is inclined to grant interim pre-arrest bail to the petitioner on following conditions. Petitioner number, namely so and so on following conditions. Others, it will be the petitioner shall appear before the IO within period of 10 days from the date of the order and cooperate with the investigation. Next paragraph. The interim bail would be at the sum of is 20,000 with one surety of like amount to the satisfaction of the arresting authority. List on 24/7/2026. Conditions, standard conditions taken.
We are deeply obliged, your lordship.
19.
Sometimes your lordship notices facts which we miss. I'll coach him, my lord. Next time you'll not.
That is the bad habit I have.
No, but that habit, Justice Arup Goswami also had. I had to put in N instead. I put it or. It makes lots of difference.
It's a bad habit.
No, you should be particular, my lord. You can't have one mistake in definition. We take care nowadays, my lord. I don't have the time to look each and every, but when I was young, I used to.
Lordship was too meticulous.
Yeah.
We don't even have 25% of that.
Yeah.
Meticulousness.
But that's required. In this profession, it's required, my lord. Because earlier, even if there was one spelling mistake, we used to change the page. But now, because of AI and all, they have the spell check and all, my
No,
lord.
then we'll have to recall the order if it is AI based.
No, my lord, nowadays, what people do, if you have mistakes, they correct it through AI or Grammarly and all those softwares have come, my lord. But it can't replace the human brain, my lord. Ultimately, it's 10 minutes that we stand before
After
your
the
lord.
next item.
We are
item
deeply
19.
19.
Please, Your Lordship. Since the applicant is a practicing advocate, he is enrolled as an advocate from Jorhat Bar Associations. The FIR is at page 11. It's a long FIR. The complaint is start from page 13, Lordship. So basically, the prime accused is Angara Borua, alias Jan Borua, Nokul Borua, and Juti Borua. This the applicant's name is mentioned in the page number 14 in the para number 5, Lordship.
Where is the FIR?
The FIR is FIR starts from page number 13, Lordship.
We'll call for the case diary here.
Lordship. The prime accused was protected by this honorable court, Lordship. The fight order dated 26/6. In this matter, I may be protected, Lord. The order is annexed with the as an annexure to in from page number 21, Lordship.
No, because the allegation is that you were the person who took the signature and handed over the documents.
Lordship, I am not taking the signatures, Lordship. The allegation is that I was present and on the day of marriage registration, which was took as a commission, and I was introduced as an advocate.
But that turned out to be fake.
That, Lordship,
That marriage certificate turned out to be fake.
that is the allegation, Lordship.
Yes. We will have to call for the case diary here. Where is his registration as a lawyer?
The Bar Council of Assam, Lordship.
Is there any document showing that he's a advocate?
Lordship, he has not, did not annex his I-card, Lordship. But he's, as a member, he is now practicing at Jorhat Bar Association as a member of also Jorhat Bar Association. In the I-card from Assam.
We have interim protection then,
Well-
if he's a member of the bar. But Mr.
SRA Nasir.
SRA Nasir, learned counsel for the petitioner. And Mr. K. Bushel, learned APP for the state. Filing this application under section 482 of the BNSS, the petitioner, namely so has paid for PRS bail in connection with page 1, Moranhat PS case number so and so, under section so and so. Next part, please. Learned counsel for the petitioner projects that the petitioner is a advocate registered under the Bar Council of Assam, Nagaland, etc., and is a member of the Jorhat Bar Association. No, but the allegation is serious against you. You brought, the allegation is that you gave the fake certificate.
But I was introduced as a advocate, and I was just I was alleged. It was alleging that the marriage certificate is right. I am not providing any fake marriage certificate, Lordship.
No, but the marriage certificate was of Jorhat.
Lordship.
So from a different jurisdiction, the sub-registrar from Jorhat cannot come to Guwahati and get it registered.
Lordship.
Commission outside the district is not impermissible.
Lordship.
But you provided that. Everything happened thereafter. You will have the case diary, but don't say something, just let the case diary, scan copy of the case diary along with.
Lordship, the section which was attracted to this fake marriage certificate is also bailable, Lordship.
Fake certificate.
Lordship, it is section 4, it's 82, it is, Lordship.
It's forgery.
Forgery.
Forgery is not bailable.
Lordship, it is not bailable. Lordship, 82, which is affected the fake marriage certificate. 82, the same offense of former marriage from the persons from whom the subsequent marriage is contracted.
'82.
82, subsection 2. Lordship.
No, not that, but we
That
giving
is
a
not
fake
attractive.
certificate.
Yes,
Fake certificate is forgery.
Lordship, yes,
Forgery would not be bailable.
Lordship. 82.
Not only that, now you take a plea that you are not the person who had been there. Somebody has impersonated you. But then in your then the lady is giving your phone number, which is telling. If she has not met you, she will not have your phone number.
What's it?
In the FIR, she has disclosed the phone number. So in 2023, there was a marriage. You gave a fake certificate. Thereafter, everything happened. Scan copy the case diary produced on. This is from Jorhat.
Sorry, I do,
Sorry,
Moral, police. Moral.
22/7/2026. Item 20. I'll just call a matter, I'll do this and then.
May I
Yes.
please, may I please, your lordship? Your lordship, these present applicants are not an accused, but they have received WT notice, your lordship, at page number 16. The present FIR date back to 2020. They are ready to cooperate, your lordship, and they are not beneficiary of any scholarship scheme, your lordship.
Where's the FIR?
Lordship, the FIR is at page number 10, your lordship. Pertains to pre-matric scholarship, your lordship.
It's an FIR of 2020, you are investigating now.
My lord,
You give an interim protection then.
my lord. Otherwise, co-accused is granted, my lord, interim protection, my lord, by coordinate bench, my lord.
Okay. Heard Mr.
A and Iqbal,
M. Iqbal.
A and Iqbal, your lordship. A dot N dot Iqbal. There's in the concept.
E. N. Iqbal, learned counsel for the petitioner. Petitioners
Petitioners.
and Mr. K. Bashir and VP for the state. Apprehending arrest in connection with page number 1, CIDPS case number so and so. The petitioner has paid for PRS bail under section 482 of the BNSS. Next part, the petitioners contend that pursuant to the FIR lodged in connection with CIDPS case number so and so, the petitioner has been served with a WT message requiring her presence before the CID on 7/7/2026 at 11 a.m. The petitioners contend that they have not received any pre-matric scholarship for which the investigation is being carried out. Next, the case diary, a scan copy of the case diary we produced on the next date of listing. Next one. Done counsel for the petitioner. Petitioners pray for interim bail, which is opposed by the learned APP for the state. Like, considering the fact that the FIR was lodged on 28/8/2020, and the petitioners are in receipt of the notice to appear before the investigating agency, the court is inclined to grant interim bail to the petitioners. As follows, give those conditions, bail bond of rupees 30,000 each with one surety of like amount to the satisfaction of the arresting authority. Other condition was that the petitioners shall appear on the. You did not appear on 7/7.
Yes, Your Lordship, we did not appear on 7/7. There was serious apprehension, Your Lordship. Even, Your Lordship, 41A notice was not served to us, Your Lordship.
Petitioners shall appear before the IO within a period of 10 days from the date of the order, failing which the interim bail shall stand lapsed by effects of time. Next list on. When?
29/7.
29/7/2026.
Deeply obliged, Your Lordship.
I'll take a break and come back.
Chairman,
Yes.
may I please, Your Lordship, I take Your Lordship page 41, my lord, kindly. In fact, my lord, I was not served with this plain petition, my lord. There was an order from honorable court to serve it to me. Time and again, my lord, we requested the claimant. They have not given it. Ultimately, we could not file the WS, my lord. Now we have been deprived to file the WS. That's why we have come before you.
Heard. Mr. S.C. Viswas, non-counsel for the petitioner. Agreed by the order dated 28/4/2026, passed by the rendered member from a motor accident claims tribunal number 3, Kamrup Metro, Gauhati, in connection with embassy case number 1776 of the 2024. By which opportunity to file written statement of the objection against the claim petition was rejected from the petitioners. Filed this application under Article 227 of the Constitution of India. Next, issue notice returnable on, give a date after 4 weeks, returnable on so and so. Petitioner shall take steps in course of the day for service of notice on the respondents by speed post with AD. There's only one respondent. Respondent AD. concerning the contents of the order dated 28/4/2026, wherein the learned tribunal had recorded that reported that the petitioner by petition number 2829/26 had stated that despite repeated requests, the copy of the claim petition was not provided to him. The court is inclined to stay the further proceedings of MSC case number 1776/2024. Till further orders. Next paragraph. The petitioner shall produce a certified copy of the order before the learned member, Motor Accident Claims Tribunal number 3, Kamru Metro, Gauhati, to bring the order to the notice of the said learned tribunal. List on so and so.
10th August.
The further proceedings, let's say, otherwise he will proceed with the evidence.
We have stayed it.
Yes.
We have stayed it.
Yes.
We take that in course of the day today.
It look right.
May it please the Lord.
Yes.
We are before your lordship notes an account of rejection of our technical bid. Kindly have a look at page 239.
If there is a technical disqualification, how far can we exercise our power?
But I'll like to persuade your lordship for that. But it has been uploaded on 1/7/26, but our technical bid has been rejected, not
Yes.
qualified. But there has been 2 bidders in this case, Milord. Kindly have a look at the tender documents at page 31, Milord.
31.
Yes.
Yes.
But the name of the work is turnkey contract for the work of supply, installation, commissioning of plant equipment and related infrastructure. So and so, so and so. But the value your lordship would see 182 crores, 27 lakhs odd, my lord.
Page number?
Page 31, annexure 3. This is the complete set of documents.
Yes.
But the last date of submission was 33/2020.
The requirement is that your liquidity must be 5%.
Yes,
And
yes.
therefore that 5% would come to about nearly 9 crore plus.
9 crore, 11 lakhs odd, my lord.
But
But I'll
your-
draw your lordship.
Your assets were 715.
Yes,
And
I'll-
then you
I'll
said you
directly-
have given a banking reference of 920.
yes, yes, yes. I'll directly take your lordship to that certificate at page 214, which we have submitted. But this is our certificate at page 214. Annexure 10 is part 20, Roman 20, my lord. And what they have found fault is, my lord, there is no CA certificate in this certificate. That is the whole case. Now, if your lordship would kindly have a look at page 215. This is my financial data, where your lordship has rightly seen, my lord, at clause 8. This is the liquidity, 7 crore 15. So I have to furnish. Now, my lord, will kindly have a look at page 216.
Yes.
Clause 5. The above annexure shall be duly certified by chartered accountant, company auditor under his signature, stamp and membership number. In case of liquidity is inadequate, the bidder may submit banking reference to establish that they have access to the required working capital. So it is in the same format, my lord, the which has been prescribed. Now, your lordship, kindly have a look at 1.3 clause, where this eligibility criteria is. Page 54, my lord.
To
Page 54.
50.
Before that, it starts at page 53, my lord, the liquid financial criteria. Clause 1.3.
Yes.
Annual turnover, clause A, your lordship has seen. Now, your lordship, kindly turn to next page, liquidity. The bidder should have access to or has available liquid assets, lines of credit and other financial means to meet cash flow of that is valued at so and so to be submitted as per Annexure 20 and 21.
You're reading which clause?
My lord, liquidity means, my lord, page 54B, top.
Yes.
The bidder should have so and so. My lord, will see the audited balance sheet and or banking reference. But here is the cash, my lord. Reference certified by the chartered accountant with her stamp signature and membership number shall be submitted by the bidder along with the bid. Banking reference should contain in clear terms the amount that the bank will be in a position to lend for this work to the applicant member of the joint venture consortium. In a case the net current assets as seen from the balance sheet are negative only, the banking reference will be considered. Otherwise, aggregate of net current assets, they will work out. The banking reference should be from a scheduled bank in India, and it should not be more than 3 months old as on date of submission of bids. But my submission for your lordship's consideration is this, Lord. But so far as banking certificate is concerned, it becomes a mandatory document because I don't fulfill the criteria of net assets because it's only up to the point of 7.15 crores, whereas the requirement is 9.11. Therefore, this document is a mandatory. If I am not submitting it, I am out. I have given that certificate, my lord, which your lordship has seen. Only thing, there was no CA certificate there. But in my respective submission, this is a directory conditions, my lord, or I have substantially compliance with the same. My lord, I have, in support of this, I have two, my lord, submissions to make before your lordship. First, my lord, where the document has been required, my lord, it has been specifically stated. Now, your lordship would kindly have a look at page 155. This is the same annexure 20, my lord, in the tender documents, my lords. As your lordship got it, my lord,
Which
page
one?
155. This is the format prescribed under which I have submitted, my lord. This is part of the tender documents which prescribe this. But in this certificate, your lordship would see there is no requirement envisaged as regard the CA certificate, my lord, which is contrast to the next financial data, my lord, annexure 21 at page 156. Now, this is my first limb of argument, my lord. The second one is, my lord, if your lordship would kindly have a look at the last page of this writ petition, my lord. Annexure 12, my lord. Well, the petitioner is based at Vijayawada, my lord. He's been executing various work under the South Central Railways. And certificate
You're
to that
showing us which page now?
251, my lord.
251.
Yes, the last page, my lord.
Yes.
But the conditions of liquidity which your lordship has seen, it is a part of 200 the GCC contract of service of railways 2018, my lord. But the Southern Railway has the occasion to interpret this, lords, and sought a clarification. Your lordship would see as regard the second financial standing clause in serial number 2, my lord. Liquidity. The bidder should have access or available liquid assets, line of credit, and other financial means to cash flow reserves. The latest audit balance sheet certified by the chartered accountant with her stamp signature, member number, and or banking reference shall be submitted. Actually, it ought to be in this manner, my lord, because a CA has nothing to do with the certificate to be provided by the bank. So, and we have been regularly, my lord, doing this work, my lord, so far as Southern Railway is concerned. In that line, my lord, we had submitted the bid. If your lordship sees the objective also, my lord, the objective is that the bank should be ready, and it should the bank would say that I am ready. But so far as financial audited balance sheet, it is in the domain of the chartered accountant, my lord. But I also like to rely upon a judgment, recent judgment of FX court. Where the requirements for this was the tender issued by the Chhattisgarh state of Chhattisgarh, my lord. As regard it was the earnest money deposit, my lord. They have said that it should be in the form of DD, and they had submitted in the form of fixed deposit. The apex court has interpreted, my lord, that no, it is also permissible as long as it is a financial interest bearing security.
But this is not referred to three judgments which have come back to back, that the author of, it would be the discussion of the author of the
Yes,
document to interpret.
there is no dispute as regard that. Your lordship has seen. My lord, in a mandatory document also, your lordship has power to judicially review whether that condition should be directory. That aspect would be, my lord, decided by the objective which the document intends to fulfill. And in fact, my lord, there are only two bidders, my lord. The financial bid of the private respondent has been opened. They have submitted a bid of around 216 crores. My lord, our bid is 200 crores, my lord. There is a gap of huge amount of 16 crores, my lord. That is also an aspect, of course, that the lordship would not take into consideration while determining the technical bid, my lord.
In fact, this entire contract is a bogus contract. I can, if I can speak out to the council sitting here,
My lord.
everybody will endorse my view. Have you traveled in any train
Yes, yes.
in the Northeast? Did you
Yes.
find the linen in a good condition?
But in fact, the same train, Sairang, my lord, I had the occasion
No,
to
because
travel.
I always go by train.
My lord.
If I am to go to Kohima, I have to go to Arunachal, I go by train.
My lord.
And never I found bed linen in a good condition.
In fact, I'll endorse your lordship's views because I have also traveled to Itanagar and Sairang, my lord. But perhaps on the other side, my lord, because to meet these difficulties, my lord, this tender has been floated, my lord, so that there could be a
This is all-
proper cleaning and all, my lord.
This is all hoodwinking of citizens. I'm compelled to travel. Whenever I travel, I'm compelled to travel with my bedding in the last old days. I travel with my bedding, which means that I have my small what do you call mat, then what do you call the sadar, and then the bed sheet, everything. I travel with that. Even the pillow, I travel with everything, just like golden old days.
But in fact, I also have the same, otherwise because of the. But they have not awarded the contractors yet, my lord. They are going to any moment. So, my lord, I pray, my lord, that they should not
Yes, what do you say?
Lordship, the
16 crore for bed linen, which is never washed.
So they are going to install a big laundry at Badarpur, my lord. That is what the tender is all.
I had occasions to travel even in first class. but I never got a towel. Unless the GRP comes and then tells people that I have to be provided with a towel, I'm not provided with one. Never a clean linen ever.
Let's say the railway has communicated the reasons of rejection of his technical bid, Lordship, on 1/7/2026. As per this communication, Lordship, on two grounds, his technical bid was rejected.
Similar work.
Yes, Lordship. It was, one is that similar nature of the, you have completed works which petitioner failed to submit documents that he has Lordship executed similar nature of works as per the tender documents. And second is the Lordship, he failed to submit valid documents to prove your T2 eligibility or liquidity as required as per the tender documents. That's it. Now, Lordship, is 28 Lordship. Eligibility criteria under T2 has been provided in page 28.
So a copy to Mr.
Yes,
Yes, sir. I've seen that.
If that has been communicated, then
No, that has not been communicated, Lord. We have made a statement. We have also submitted representations, Lord.
but they are not producing it before us.
Communicated, Lordship.
Lord, we have written many representations, Lord. We have also made a statement that so far that is concerned, Lord, we have not been,
We'll record this.
my Lord. So far, Lord, similar work is concerned, Lord. We have also submitted our checklist of documents where we have indicated, Lord, everything we have submitted, Lord. There are works also, Lord, experience work certificate that we have annexed.
We are listing the matter again on 15th.
My Lord.
We are issuing notice
Hmm.
and also prayer for interim relief.
But till then, they should not tell.
So that we are not saying it right now because they have now produced before us. We are recording this
My Lord.
in the order.
My Lord.
But Mr. R. Dubey, learned counsel for the petitioner, as well as Ms. R. Devi, learned CEC for the respondent. For respondent was 1255. Okay. Next are the by filing this repetition in Article 226 of the Constitution of India, the petitioner has assailed the rejection of technical bid of the petitioner by a what will we call it? Portal information.
Yes.
We have portal information dated 1/7/2026.
Aye.
Uploaded at 16:45 hours. Full stop. The petitioner had next para, the petitioner had participated in the tender for turnkey contract for the work of supply, installation, commissioning, page 26, copied from the name of work. It's the NIT, huh? What's with the e-tender process of NIT numbers also? What is the tender number in page 26?
That MAC LMG ET 14 dash, Lordship will find at page 37 would be more clear. Sir.
Page 37 is not clear.
At the top left hand corner, block, tender number MECH MAC
Okay.
dash LMG
Then take it
dash
from page,
ET.
page 37. NIT tender notice number so and so for name of the work. Full stop. The petitioner projects that the rejection of the technical bid was on flimsy ground, that the banker's reference was not certified by the chartered accountant. And in this said connection, the petitioner places reliance on a correspondence bearing number page 251. Number so and so. Issued by the South Central Railway. Which amongst others, clarified that accordingly, it is submitted that so far as balance sheet is concerned, the same has to be certified by a chartered accountant, but the banking reference need not be certified by a chartered accountant. Stop. It is further submitted that the online disclosure in the portal regarding rejection of the technical bid did not contain any reason, and though the petitioner had submitted representation on 30/6/2026 and 1/7/2026, these are the two.
Yes, yes.
No disclosure for the reasons was made. Next paragraph. At this stage, the learned CGC has produced a copy of communication dated 1/7/2026. Getting numbers so and so. So the contents of the said communication is extracted below. Full stop. Next paragraph. In response, the learned counsel to the petitioner has submitted that he has specific instructions to the effect that the said communication dated 1/7/2026 was and or any other communication disclosing the reasons for rejection of the technical bid has not been communicated to the petitioner. Next point. Issue notice including notice on the payment for interim relief, which is made returnable on 15/7/2026. Post. In view of the urgency expressed, the petitioner is permitted to serve notice on the respondent number 6 by email. You have the email address?
No, good. I'll try to have what the railway authorities can provide, we can.
To email to stop. We direct the learned CGC to obtain the email address of the respondent number 6 and communicate it to the learned counsel for the petitioner by 8/7/2020. Sorry, today's 9 by 10/7/2026. In the meantime, the petitioner, the petitioner can load the process to the registry of the court, and thereafter the notice be served on the respondent number 6 as indicated above. To stop. Next paragraph. Next paragraph. On the next date of listing, the respondents number 1 to 6, 1 to 5 shall also produce the proof of service of the communications referred dated 1/7/2026. Before the court, with a copy thereof to the learned counsel for the petitioner. List on 15/7/2026. So you are requested to provide the email address and give it to Mr. Dubey.
Yes.
In the meantime, you do the process and then to the registry and then serve it by email.
I'm like,
23.
Your citation. Yes.
Lordship, the petitioners before your lordship have been served an eviction notice dated 1/7/2026, your lordship, which is at page number 39.
It's a government land.
The government land, but your lordship, the principal laid down in Salakuddin has specifically stated that a notice and hearing is to be take place, your lordship. Basically, these petitioners are landless because even they are evicted, they have no other place to go, your lordship. So kindly opportunity of hearing may be accorded to us so that we can place our situation before the concerned authorities, your lordship.
But he must give notice before,
Lordship,
before election, and that
submission,
notice,
Lordship. Kindly peruse the page 39 notice, Lordship.
page
39, Lordship, Annexure 1.
39.
Yes, Lordship.
Yes.
These are addressed to 15 persons, individuals, Lordship, and the subject is encroachment of government land. In pursuance to the concerned LRA report that you were encroached the government land at Revenue Village, Nidanpur, Part 2 at Government Dag number 274, measuring so and so, so and so. Now, Lordship, kindly peruse the paragraph 3 of the writ petition.
No, but you'll have to do take the hearing.
Lordship, they admittedly are staying in separate ducts. So what is their headache for this Lordship? 274. If they have not encroached this Lordship, then why they are with this Lordship? Admitted, this is their own admission, Lordship. They are staying in, occupying the DAG number 275. And this pertains to 274, Lordship. And that apart, Lordship, they have stated that they have prayed before the circle officer, Lordship, for allotment of land. There are some, Lordship, documents that they have submitted, Lordship, which these are in pages starting from 80. All these are rejected, Lordship. The individuals' names are there. All these are rejected in 2025, Lordship. So there is nothing on record to show them that, Lordship, this particular tag has been occupied by them and with this, Lordship. So the eviction notice that has been, Lordship, issued. So it does not, Lordship, affecting them, Lordship. If at all they are not encroached this land, Lordship. And as per Land Revenue Regulation, Lordship, 18, Section 18, Lordship, this is only 15 days notice, Lordship. The Deputy District Commissioner has the absolute right over the government land, Lordship.
Everything is.
So here it is admittedly, this is issued on 1st July, Lordship. So 14 days time is given, Lordship.
No, you see,
So there is nothing, Lordship, illegal has committed by the authorities, Lordship.
no, but you see, he's claiming to be 274,
Yes.
then at least they should not be evicted from that 274 in guise of 275. You cannot.
This is different, Lordship. If it is issued on 274, Lordship, at least these 274 should not be, Lordship, may not interfere in this, Lordship. As admittedly, they are occupying 275, Lordship.
Kindly pursue page number 70 and accept 3. We're making 2000, page number 70, your lordship. And accept 3, your lordship.
No, because there's one difficulty. You see, from this, first of all, you please come to page 61 onwards. Correct. We are just taking at random the first petitioner here is Jaharuddin, page 40. Correct. Now let us see this Jaharuddin at page 61 onwards. This Jaharuddin is not there till page from 61 to 69. Correct.
Zaharul Ali, your lordship, name, there is a mistake in your lordship.
We don't know about that,
Yes,
but your page 40 is Jaharuddin.
yes, your lordship.
Correct. Now please come to page 80. Again, this is Jaharuddin. You filed an application which was
Yes.
rejected.
Yes, your lordship.
Correct.
Yes, your lordship.
The reference is 11/11/2024. So what did you apply for that you have withheld? Your request for allotment for which land was or for settlement of which government land was made, which was rejected. That application you have withheld.
Lordship, as per the guidelines laid down in Salakuddin, when we accorded an opportunity to be heard, your lordship. Let us state all this before the concerned authorities.
But you are not there at 275.
Yes, Lordship. Notice is not issued in respect of 275,
This
Lordship.
can be set aside, your lordship,
No.
in regard to us, your lordship.
So that will continue in you are in 270. The eviction is on 275.
Lordship,
Then you will have to.
This
give-
is not affecting them, Lordship.
No, but then they'll have to be protected from eviction from 274 if that.
274, Lordship. And their admission is they are staying and occupying 275.
Lordship, can you come to page number 70, your lordship?
70.
70, your lordship.
Yes.
If, can you 71, your lordship, 5, allotment of land and settlement to individuals. This is a district land advisory board resolution whereby a resolution was taken to allot 300 bighas of land to the landless person, and in accordance with already land has been granted, periodic patta has been granted. We had been left out, your lordship.
But their Lordship, the allotment of land is worth 300 bigha, yes. But this pertains to DAG number 276, 285, 286, 275. These are page 77, Lordship. You are.
77.
Yes, page 77. Approve the matter of allotment of land measuring so and so covered by DAG number 276, 285, 286, 275 in the Nidanpur Part 2 under Lakhipur Circle. So, Lordship, they are no way affecting Lordship 274, Lordship. So, why they are on this, Lordship?
Served a notice.
So, this is
that
an
way
admitted fact that they have engrossed this, Lordship.
as per Salakuddin's guideline, we may be accorded an opportunity to be heard, your lordship.
No, not when you are not the occupier of that land. You don't claim to be the occupier of that land. What is that citation of Salakuddin?
Salakuddin WPC 1057 oblique 2022.
You have a copy?
Yes, your lordship.
Please, pass it on.
Rule 18 has been described detail, your lordship. Kindly, if you can, from para 54, 55, 56, 57 onwards, your lordship.
Lordship, this will apply when they are in occupying the particular land,
Notice has
Lordship.
been served, your lordship.
Para
54, your lordship. 55, 56, 57 onwards, your lordship.
But then, Mr. Khalid, it comes to the same point again. You see, you claim to be in possession of 274. Correct?
Yes, your lordship.
Then if the eviction is carried out in 275, why do you require to have a hearing?
So notice has been served, we have received the notice, your lordship.
But you are not there.
And we are not there, that is our grievance, your lordship. That is why before your lordship. Your lordship.
Where is the notice to you?
Page 39, your lordship.
We are giving them time for 7 days from today to file their response against the notice of eviction. And you will give them an opportunity of hearing and then proceed with the matter.
Lordship, when admittedly they are not in a position
You
of.
issued them notice. They claim to be in 275. You give them a notice.
On 270,
In
because
respect of
this is,
274.
Lordship, this is clearly written, Lordship.
No, that's okay.
You
But they,
encroach the government land.
we understand, but they have a right to be heard.
Lordship, as
In guise of 270,
18 Lordship,
in guise of 274, you can't evict him from 275.
when it is 274 Lordship, I think this will be restricted to 274 only, because these are more
No, you
specific,
give
the
them a
which
hearing.
land are for the
They will
earmark
stop.
for the settlement of.
It's okay, but they, you see, you have given them notice. They say that they are not in 274. They are in 275.
275 Lordship, if they have not encroached upon this particular DAG Lordship, then
That's not your case. Page 39 does not, that's not the case of the government. that you are occupying 275 and you have encroached to 74. If they have encroached to 74, you will evict them.
We are not admitting their, because their cases are already been rejected, Lordship.
That's okay, but they are now claiming 275. If you have rejected, you are not claiming eviction under 275. You are giving the notice under 274.
In 274, Lordship.
But 275, there is no
In
eviction.
most of the cases, Lordship, these things are happening, Lordship. They have encroached upon the more into other DAX and all this, Lordship.
No. You see, these things are now very easy to know. When you can have Google Maps and tracking of the
Lordship.
land, you can definitely identify which is 274, which is 275. And if if you don't give them notice in 275, can they be evicted in the name of 274? They can't be evicted.
But the judgment that they are relying, Lordship, there also it is that there, because the
notice
case
is
is
given
different,
and
Lordship.
they
They
have
were in possession of that particular land, Lordship. The case law that they are citing here before your Lordship, these are the petitioners who are in possession of that particular land. Here, admittedly, Lordship, they are not in possession of this land,
Can
Lordship.
you evict without notice?
Yes, Lordship, 18 to 15 days notice is there. So the notice has been
Give the
given,
hearing,
Lordship.
you give them a
Where is the opportunity of
you
being
have
heard
given
and
them
all
a-
this,
you have
Lordship?
given them a notice, you hear them.
Because these are admittedly a government land, Lordship.
You have given them a notice. Notice is given for what?
Yes, in compliance to Rule 18.2, Lordship.
So the
Yes,
party will
Lordship.
have to take a decision.
Yes, Lordship.
Then why can't he participate there? Tarakuddin says only that.
But
You know-
Salakuddin is different because
No, it's
they
not.
were in particular
I'll tell you why.
possession in that particular
I'll
land.
tell you why. This Salakuddin emanated from an order passed by this bench.
Lordship.
The it was a question posed by this bench, and thereafter the other bench took up the matter and
Took
the
up the
hearing
matter.
was
Yes,
taken
Lordship.
place. We know under which facts this was decided. 18.2 says that notice the authority will have to
15 days. 15
no
days.
will have to take subjective satisfaction. So 18.2 subjective satisfaction on what? He'll have to file his response. Give them an opportunity, hear it and decide it. Now, how will you accept the what you call the reply by them in the Deputy Commissioner's office? Where do you give them a place to deposit their what you call the reply, or do you have a email address to which the
Lordship may take it up at 2, Lordship. I shall get the instruction and appraise your
you give the
Lordship.
email address of the authorities
Lordship.
through which they can give the email, and then the authorities
Lordship.
will have it and then decide the matter.
They can physically go and deposit their documents and.
We don't want second round of litigation.
Lordship.
It must end here. You will give you a place where you serve notice the reply, and they arrive at a subjective satisfaction, and they will decide with the matter. Your
I
case
shall
is only
appraise that to
270.
Lordship.
Your case is only 275, not 274.
Yes.
So if that is taken care of, you have nothing to worry. And we are not in favor of the petitioners because of the reason we have shown you that.
Yes, sir.
You applied and it was rejected.
Yes, sir.
What you applied, you are not showing us. So we could have dismissed your petition on that ground alone. But you're not doing it because since in the eviction matter, we will take it up at 2.
Lordship.
Or something like that.
Deeply honored.
It should be coming, I think. We'll take it up after some time. It will come.
May it please your lordship. My lord, the issue here in my lord, illegal acceptance of the technical bid submitted by the respondent number 4, in spite of the fact that he had concealed two number of works awarded to him before the issuance of the NIT, present NIT, my lord. At page 44, Lordship will find the NIT.
Just a moment.
Right.
Uh, Mr. Nayak,
Lordship,
a complaint has been made on 19/6.
Yes.
Why no response has been given?
pardon, Lordship.
In this regard, we think that if you have read it correctly,
Yes,
page 312 is a
Lordship.
complaint of arbitrary evaluation,
Yes.
and then letters followed by letters dated 28, 24, and 27. Why the authorities
In
have
fact,
not?
Lordship, petitioner filed his complaint, Lordship, on
13/6/2026.
13/6/2026. On the basis of that complaint, Lordship, clarification was sought from the person, that is respondent number 4. And after receiving his reply, Lordship, BEC again considered the issue and accordingly decided, Lordship. So that decision was on 19/6/2026.
19/6.
Yes.
Okay,
So on that day, Lordship, technical bid was finally decided.
okay, then we hear you.
That Lordship will, otherwise, Lordship, vacation time, I would definitely not like to hamper, burden your Lordship. To the extent of notice, Lordship, I have no objection, but beyond that, Lordship, I
Let us
have to
kindly be
make-
maintained,
no,
my
Lordship,
lord.
no.
As my lord, at page 303, my
That
lord,
is not-
kindly turn to page 300, my lord. Page 300. This is the list of existing commitments of the respondent number 4, which was submitted along with his technical bid. These are the, as per the respondent number 4, these are the existing commitments he has, my lord.
Yes,
Page 300 to 302. Next, my lord, kindly turn to page 303 and 304. These two work, my lord.
Hmm.
The awarded to the respondent number 4. At page 303, the work was awarded on 3/2/2026 by the Chief Engineer Roads. And at page 304, this work was awarded to respondent number 4 on 7/2/2026 by the Chief Engineer EAP PWRD. These two works, my lord, has not been disclosed by the respondent number 4 in the technical bid, my lord. In this respect, my lord, kindly turn to page 58, clause 4.11, my lord. 4.11. Page number 58, the part of the tender document, my lord.
yes,
4.11, my lord. Even though the bidders meet the above qualifying criteria, they are subjected to be disqualified if they have, number 1, my lord, number 1 is relating to this issue, my lord, made misleading or false representation in the forms, statements, affidavits, and attachments submitted in proof of the qualification requirements. Then, my lord, if any misleading statement is made, then the bid is liable to be rejected, my lord.
yes.
My lord, kindly turn to page 78. This is G, part G, corrupt or fraudulent practice. Clause 34, my lord, corrupt and fraudulent practice. Clause 34.3, small b, down below. The definition of fraudulent practice is given, my lord. Fraudulent practice means a misrepresentation or omission of facts, or suppression of facts, or disclosure of incomplete facts in order to influence the bidding process. This is the definition of the fraudulent practice, my lord. And page now, my lord, kindly turn to page 86. This is the section 3 part of the contract agreement, tender agreement. This relates to, my lord, information regarding qualification of the bidder.
Page number?
Page 86, my lord. The bidder has to meet the bid capacity, my lord, to being qualified for participating in the work in question, my lord. The bid capacity deals with clause 4.2.
86.
Page 86 is the information regarding qualification, my lord.
Yes.
Page 86, section 3. This part regarding information regarding qualification. If lordship kindly turn to page 101 for a moment, my lord. To calculate how they will calculate the bid capacity, my lord. Page 101.
Yes.
The calculator value of B. Before that, if lordship allow me, lordship, can I take lordship to page 52 and 53 for bid capacity, my lord? How the bid capacity will be calculated, my lord. Then the value will become, my lord.
No, you come to the main crux because if we examine so many things in vacation.
Yes, my lord,
code,
that's
not
page
be-
101, my lord. For a moment, 101, my lord. This has to be submitted by the bidder, my lord. May I read, my lord? A table containing value of all existing commitments and ongoing works to be completed during the next 5 years as follows. The bidder has to give all the existing commitments, my lord, which he is going to complete within 5 years. All, my lord. In the instant case, my lord, lordship has seen 2 number works has been concealed by the bidder, my lord. Down below of that page 101, my lord, before 2 blocks, the last sentence, my lord. The sentence starts from no awarded. As lordship find it, my lord. Before the 2 box, my lord, the sentence, last sentence start with no. Page 101.
The only paragraph is the statement showing value.
Yes,
of
ma'am. This paragraph, in this paragraph, the last sentence, my lord.
No awarded.
Yes, my lord. No awarded ongoing works has been left in the aforesaid statements which has been awarded to Messrs. So and so individually and oblique or so and so, my lord. So this, they have to file this affidavit before the authority that we have not left any work that has been awarded to us, which we are going to complete within the 5 years. The lordship has seen that they have not disclosed 2 numbers of works, my lord. And for that, my lord, as I have indicated, my lord, as per clause 34, this is amounts to, my lord, fraudulent practice, corrupt practice, and therefore, my lord, their bid security has to be curtailed, my lord. And their bid is not liable to be accepted, my lord. In this regard, my lord, if lordship allows me, there is a judgment passed by this honorable court, my lord. The same issue, my lord, the petitioner is the same, my lord. In this case, my lord, the petitioner, the present petitioner, submitted a bid, my lord, in respect of the tender issued by the same respondent number 2, National Highway, my lord, Chief Engineer, National Highway. In that tender, my lord, the petitioner has not disclosed the work awarded to one of its director, Mr. Matlebuddin Ahmed, my lord. On that ground, his bid was rejected. The petitioner's bid was rejected, my lord. The petitioner approached this honorable court. The writ petition was allowed. Ultimately, the matter went to the division bench at the instance of the state of Assam, PWD Chief Engineer, my lord. And the division bench of this honorable court was pleased to held that disclosure is must, my lord. Paragraph 33, my lord. If lordship, the observation made by this honorable court, my division bench. Paragraph 33.
Yes.
Having taken into consideration the above fact situation, we are of the view that the company cannot blow hot and cold at the same time. If the company had placed reliance on the past experience of its director to demonstrate its capacity to execute the work for which the NIT was issued, the company was also obliged to disclose all the existing commitments of its said director to demonstrate its capability to execute the work satisfactorily. Next, my lord, kindly turn to paragraph 39, the next page, my lord. This is the finding, my lord. Paragraph 39. May I read, my lord? In the above facts and circumstances of the case, we are of the considered opinion that the Technical Bid Evaluation Committee did not commit any illegality in declaring the bid submitted by the company as non-responsive on the ground that the company had not disclosed all of its existing ongoing works, and this amounted to deliberate misrepresentation of facts, rendering the company liable to be disqualified as per clause 2.6.2 of the RFP. So in my humble submission, my lord, this observation made by the Honorable Division Bench of this Honorable Court is squarely covered in the facts of the incident case. There is deliberate misrepresentation on the part of the respondent number 4, and the same was brought to the notice of the respondent number 2 by representation dated 13/6/2026. And in spite of that, my lord, as per my instruction, my lord, on 19/6/2026, Financial Bid Committee evaluation meeting was held, and the respondent number 4 was declared L1. However, my lord, till date, no work order has been issued or contract agreement has been executed.
Yes.
So Lordship has heard more than being agreed for his rejection, Lordship. He is having heartburn as the work was allowed to respond number 4. That is the basic submission, Lord. Now, in this submission, Lordship, I am still trying to find out one statement, Lordship, which states, if the bid of respondent number 4 is cancelled, then he will be the person to whom the case will be, tender will be allotted, Lordship. That statement is missing. Now, Lordship, here we have, Lordship, 2 lowest bidders, Lordship. One is L1, one is L2. L2 is not a party. One. And even if the bid of L1 is cancelled, so claim of L2 will always be there. So even in that situation, Lordship, he is not going to get the contract. Thirdly, Lordship will see, so far as that judgment is concerned, there the issue was, prior to formation of the incorporation of the company, Lordship, he was the proprietor of the company. And the issue before the court was whether then subsequently company was incorporated and he became a director of the company. And the issue was whether it was obligatory for him to show the contract that was issued in the name of the proprietorship should also been shown as a liability or asset of the company. So that was the issue there, basic issue. And therein, Lordship, he has filed 4 writ petitions in that situation, Lordship. 4 writ petitions he filed, 3 writ petitions he withdrawn, because of the fact that in other cases, Lordship, his financial bid was lower than the successful bidder, Lordship. So that same situation will apply here. He will have first to make a statement that my financial bid, I don't know what was his financial bid because it was not open. Now it is open, it has been uploaded so far as the L1 and L2 is concerned. You will have to make one statement that my financial bid is lesser or lower than L1 and L2. So I have every possibility of getting the contract if the bid of L1 is cancelled. That is not there. Most importantly, Lordship, this is a case, Lordship, of maintenance of a large portion, a large stretch of road, Lordship, in the Upper Assam, Lordship, for maintenance work for the next 5 years. So we are still not issuing the LOA only because of the fact we are waiting for approval from the ministry, Lordship. Once we receive the approval, immediately we will issue the LOA. So at this stage, Lordship will not stop or stay the impugn order here. Impugn order means the financial uploading, Lordship, at this stage. Otherwise, it will adversely impact the public interest, Lordship. So that is my submission, Lordship. One more statement, Lordship. My friend has shown page 58, Lordship. This is clause 4.11, page 58. Lordship, here 4.11.1 made misleading or false representation in the forms of statements or affidavit, etc., etc., Now, Lordship, if Lordship reads at page 78, Lordship, 34.3b. What amounts to fraudulent practice, Lordship? B, page 78, 34.3b. Fraudulent practice means a misrepresentation or omission of facts or suppression of facts or disclosure of incomplete facts in order to influence the bidding process, Lordship. In this case, Lordship, the bid capacity of the contractor required is 57 crore, Lordship. And when the authority considered, Lordship, it is found, even if these two bids are not taken into account, Lordship, his base capacity goes up to 3,000 crore, Lordship. And after taking these two contracts in record, Lordship, it comes down to 3,304 crore. So it is much higher than 57 crore. So it has no, it cannot be interpreted as in order to influence the bidding process. So it will not influence the bidding process in any manner. 57 crore and his bid capacity is 3,000 crore, Lord. So that is the distinction between the earlier case and the present case, Lord. That's my submission.
My lord, may I point out one thing? My lord, in this bid petition, my lord, my prayer is, my lord, to reconsider my technical bid, my lord. And my lord, clause 34.3.b, by not disclosing the existing works, my lord, the respondent number 4 is trying to influence the bidding process, my lord. If, my lord, that action can be taken by the respondent number 4, then what meaning the respondents will give to clause 4.11, my lord?
And where is that decision of the authority?
My lord, a technical bid evaluation of lordship will find at page 297. Since, my lord, we are not qualified in a technical bid, so we are not allowed to have access the financial bid meeting minutes, my lord. Page 297. This is the technical bid.
No. Mr. Nayak said that they took a decision thereafter.
That was not communicated to us, my lord. Now I come to learn, my lord, that they have taken a decision, my lord. And at the same time, they submitted that until and unless they get the approval from the ministry, they will not finalize. So what decision they have taken, my lord, that is not known to us, my lord. Page 297 is the technical bid meeting minute, my lord.
He submitted his representation on 13/6, Lordship. Reply received from the L1 bidder, Lordship, on 18/6. And BEC meeting took the decision on, considered the clarification and representation made by the petitioner on 19/6/2026. Time is also mentioned 11 a.m. Means, Lordship, this has been uploaded, Lordship. And financial bid was open on 19/6. Today, Lordship, it's 9/7.
Can you ask someone to, in your department, to give us access so that we can open it in the net and see it?
Lordship,
If it is
it can only password is given only to the successful bidder and to the ministry, Lordship, central government, Lordship. Even state government cannot.
It is uploaded. How do you understand that it is uploaded?
I can place printout, Lordship. Printout I can give, Lord.
You can have it printout.
Yes, Lord.
Is it? Maybe.
I have to collect it only then.
You can ask them. You can call us back.
Will call after.
Take it up after some time.
Lordship.
And I believe there is no difficulty in for them to give us the access.
No, now he cannot be given the access, Lordship, because
no, to the court.
Court.
To verify
Lordship, if Lordship passes it, the order, Lordship, that can be given, Lordship. Otherwise, without the direction, Lordship.
At one point of time, we called the authorities to have it.
No,
we have demonstrated in a court that it is uploaded. We have seen that.
That, in that case, I was also there, Lordship. In that case, it was a case from Baran. Most probably it is Mansur Ahmed. He was also there, Lord.
Mansur Ahmed also. My colleague is there, also not there.
It's okay, but you
let me have a copy of that.
If you can get a copy.
of the technical bit of, in the
No, that
finance.
decision.
Technical will be there, my lord, financial
Yes.
related.
In the uploaded copy, lordship, that decision will be there, I think.
After funding.
After.
Yeah.
Yes. Item 23.
Lordship, I just had a conversation with the District Commissioner Gwalpara Lordship. So what he intimated, Lordship, this will be confined to 274 only. This will not be, the as notice has been issued in respect of DAG number
That's okay. You
274.
give them a hearing and then dispose it out.
Lordship, then another very short date, Lordship, within this, they will, other this may be required for some government, these things, Lordship.
Something we are giving only extended 7 days time to them to give their reply. Any day you can fix and notify them for hearing
Lordship,
after that. We are not giving more time.
Lordship. And Lordship may dispose it if Lordship.
Yes, we dispose it.
Lordship.
We don't want to record your statement because then you, if there is a contempt, then you become a subject matter of the
Lordship.
contempt jurisdiction. So that's why we don't want your statement to be recorded unless you say so.
Lordship.
But then you always take a risk.
Lordship.
That's fine. But Mr. Z. Khalid, learned counsel for the petitioners, also heard. Ms. M. Bhattacharjee, learned additional senior government advocate, appearing for. You'll be appearing for all?
I can appear, but even though there are, Lordship, actually,
One is-
respondent number 1, there is nothing. This is meaningless, Lordship. Which department, nothing is mentioned. 2 is revenue, 3 and 4 I am appearing. Lordship may record my name. 1 is.
One is no one.
This is vague, Lordship.
One is no one.
Yes, no one.
So you'll be appearing for respondent number 3.
3, 4,
3 and 4, okay.
Lordship.
Appearing for respondent number 3 and 4. Next one. At the outset, the learned additional senior government advocate has pointed out that the respondent number 1 is the state of Assam, represented by Commissioner and Secretary to the government of Assam, without indicating any department, and therefore she is unable to appear. For the respondent number 1, as there is no clarity of the concerned department. So her submissions are accepted. Next one. In brief, the case of the petitioners is that they are all occupying government land covered by DAG number 275. Full stop. The petitioners are in receipt of a common eviction notice dated 1/7/2026, bearing number page 39. Number so and so, dated so and so, no? 16, make it right. Alleging that the petitioners have encroached government land at Revenue Village, Nidanpur, NIDANPUR, Part 2, Roman 2, at government DAG number 274, in respect of land measuring 13 bigha, 2 katha, 10 lecha, and accordingly the petitioners were directed to the petitioners along with one more notice. The 14 petitioners along with one more notice were directed to vacate the government land within 14 days from the date of receipt of notice. By referring to the case of Mohammed Salekuddin, MD, Salek SALAK Uddin versus State of Assam and others, WPC 1057 of 2022 decided on 27/6/2024, this court has held that the notices were in receipt of eviction notice under Rule 18 within bracket 2 of the under the rules, under the settlement rules. Under the Assam Land and Review Regulation, we were entitled to put forward their bona fide claim in respect of their land, and that under Rule 3 of the settlement rules, the district commissioner was required to arrive at a subjective satisfaction that there is no bona fide claim of right involved. Next paragraph. Next paragraph. Her contract, the learned additional senior government advocate has submitted that as it is a admitted case of the petitioners that they are staying in DAG number 275, and then by the impugn notice dated 1/7/2026, the petitioners were directed to vacate the land under DAG number 274, the petitioners were not entitled to raise any objection or to dispute the government right to have land covered by DAG number 274 evicted from encroachers. Full stop. By referring to the minutes of District Land Advisory Committee meeting held on 3/11/2006, which is annexed to the rate petition, it is submitted that as per the documents produced by the petitioners, this approval for allotment of land was in respect of land measuring 300 bigha, 0 kata 0 dacha, covered by DAG number 276, 285, 286, and 275 of village Nidanpur, Nidanpur, Part 2, Roman 2, under Lakhipur Circle, Lakhipur Circle, in favor of 607 landed families out of the land previously reserved for ex-servicemen. So accordingly, it is submitted that the said allotment decision taken by the Land Advisory Committee of Gauhati district would not come in the way of the government to have government land covered by tag number 274 to be evicted of encroachers. Next paragraph. You got the address, that email address or something, so they will accept it.
No email address, Lordship, they can submit it before the District Commissioner Gwalpada or
you see-
the issuing authority, Lordship, Circle Officer. I shall
So you see,
intimate
the
him.
problem we faced earlier, in
Lordship.
earlier round of litigation, is that people come back to the court and say that there was nobody to receive it.
No, Lordship,
They-
I will intimate Lordship accordingly. I could not obtain the phone number of the Circle Officer. That's why, Lordship, I could not convey this.
But if it can be sent by email, then these issues are first off.
Lordship.
So nobody can come and complain that their applications were not accepted.
They may submit it before the Circle Officer who has issued this, Lordship. I shall personally intimate him.
And they will give an acknowledgement of receipt.
Lordship. Office of the Circle Officer, Lordship.
No, it will not be a circle officer.
Circle Officer has issued this notice, Lordship,
Okay, okay.
issued by the Circle Officer. Otherwise,
You're-
this will be
you're
on
right.
their part, Lordship.
You are right.
Travel to Gwalpada.
You are right. Next one. Consider the materials available on record and the submissions made by the learned counsel for the petitioner and the learned additional senior government advocate. And also considered the judgment of this court in the case of Mohammed Salekuddin within bracket Supra. Next para. It is not in dispute that the eviction notice dated 1/7/2026 is for eviction to be carried out on government act number 274 in respect of land measuring 13 biga 2 katha 10 lecha. Full stop. The specific reading in paragraph 3 of the petition is to the effect that the petitioners are staying in act number 275. Full stop. Therefore, comma, in light of the decision of this court in the case of Mohammed Salekuddin within bracket Supra, there is a requirement of the authorities duly empowered under Rule 18(2) of the settlement rules and is 18(2) read with Rule 3 of the settlement rules to arrive at a subjective satisfaction that there is no bona fide claim of right involved. Full stop. Accordingly, comma, the petitioners who claim to be in possession of land covered by Act number 275 have a right to make a representation before the circle officer, Lakshipur Revenue Circle, that they are not in occupation of government Act number 274, which is the land covered by notice dated 1/7/2026. Accordingly, the court is inclined to grant liberty to the petitioners to submit their individual representation before the circle officer, Lakshipur Revenue Circle, Lakshipur, District Gwalpara, within 17/7/2026, along with the certified copy of the order. The court is also intended to provide that the circle officer shall not refuse. You say that the circle officer, on receipt of the individual representations, shall acknowledge the office copy, acknowledge the receipt thereof in their office copy of the petitioners, and thereafter arrive at a subjective satisfaction that there is no bona fide claim of the right involved, insofar as the right of the petitioner over land covered by the Act number 274 is concerned. Next, it is further provided that the petitioners shall provide their email addresses in their representation so that decision, if any, taken by the authorities can be communicated to the petitioners through email. Any communication of the order passed in the email address would be deemed to be due service of the same to the petitioners. Next para, in the event it is needless to say that in the event the circle officer, Lakshipur Revenue Circle within bracket respond number 4, arrives at a satisfaction that there is a bona fide claim of right involved of the petitioners in respect of land covered by the Act number 274, no bona fide claim. No bona fide. In that event, the authorities would be entitled to take such steps as the law may so require. Full stop. In accordingly, the regulations are disposed of on terms as indicated above at the motion stage without issuance of notice on the respondents. Next para, it would be open to the learned additional senior government advocate to transmit a downloaded copy of this result to the respondent authorities. You are giving you back your this again.
$25.
Wait, please, Your Lordship.
Yes.
My lord, hearing, my lord, in this case, my lord, petitioner having a periodic patta land, my lord, purchased by a sale deed, my lord, after obtaining permission from Deputy Commissioner, my lord. Now, after 10 years, my lord, the respondent number 2 has issued this notice at annexure 5, my lord, page 41, my lord.
So this is there, this provision is there in almost all the acts. It is there in the GMC Act, in the GMDA Act.
My lord.
If there's a land which blocks the natural, flow of water,
My lord.
then they have a right to
My
acquire
lord,
it.
that is there, my lord, but my representation is at next page, my lord, at annexure 6, my lord, page 42, my lord.
Page
That
42,
has not
yes.
been considered at all, my lord. And my case is that, my lord, originally that flow, that small stream, my lord, was not going through this plot of land, my lord. Since, my lord, this has been blocked by some public, my lord, and without survey, my lord, directly this notice has been issued, my lord, directing me to demolish within 7 days, my lord. Where I have been staying with my family in my house, my lord, which has already been mortgaged also before the bank, my lord. My lord, only, my lord, grievance is that, my lord, since I have already filed this representation, my lord, at least I may be heard, my lord. And moreover, my lord, since, my lord, along that stream, my lord, there are more than 200 people are there. My lord, I have this, 3 people are chosen to issue this notice, my lord. I am one of them, my lord. So my only grievance is that, my lord, without any survey, my lord.
Principle of minimum damage.
My lord. But my lord,
See, but I'm just asking you on the basis of what you have submitted.
my lord, I have also enclosed the map,
You see,
page 40, my lord.
we see, let me give an example. My examples are always horrible, so therefore excuse me for that. You see, in Nalbari area, there's this Pagadian river.
My lord.
It changes its course every few years.
My lord.
Those part extends up to part of Manas.
My lord.
Now, if there's a change in course and for some obstruction somewhere,
My lord.
the rivulet changes its course from place A to place B. Can there be a defense that you don't clear up A and therefore why you are clearing up B? Can that be a good defense?
But my lord, my grievance in the representation, I had stated that, my lord, since it has been blocked by the public for constructing some road, my lord, thereafter, my lord, this stream has come this to the part of this land, my lord. And moreover, my lord, if that is found, my lord, after considering my representation, that I have to, my lord, vacate, my lord, then, my lord, since it's a periodic patta land, my lord, I have purchased by a sale deed, my lord. At least by observing due process of law, my lord, this has to be done, my lord. Not a government land, my lord. Deputy Commissioner himself has given permission to, my lord, purchase this land, my lord. Now, my lord, suddenly, my lord, given this notice, giving only 7 days time to, my lord, demolish, my lord. Wherein I have been residing, my lord, with my family, my lord.
In that act, there is Disaster Management Act. Disaster Management Act.
Lordship, the order of 29/6, Lordship, it is very clear. There was a report from the circle officer, Tekya Julie, Lordship. And afterwards, this has been confirmed that there was encroachment, Lordship, blockage of the stream, Lordship. Thereafter only, Lordship, this has been issued.
While issuing, my lord, NOC for the sale, my lord, same circle officer, my lord, provided the, my lord, report, my lord.
No, that is different.
My lord, whatever.
And in the representation also, there is some admission, Lordship, paragraph 3, they have stated, this is around
Just-
300
just-
meters from the land of the
Just a moment,
Lordship.
32.5. Hmm.
My humble submission, my lord, the constitutional right to property and right to shelter, my lord, cannot be taken away like this, my lord, by way of an executive order, my lord. And when, my lord, I have filed a representation, my lord, after receiving that representation, my lord, my only humble submission is that let them consider the representation, let me be heard, my lord.
Yes.
Yes, Lordship. If they have received Lordship, then Lordship kindly allow us. By next week, I shall communicate that they to dispose of the representation dated 2nd July.
So, my lord,
Lordship.
the delivery report annexed at page 48, my lord, I think it's received, my lord.
48.
48, 47 is the postal visit, 48 is the delivery report, my lord. So let them
We don't
find out.
understand why, if they're so urgent in nature, why do you give this by registered post so that
By hand also we have given, my lord.
Well,
By,
given?
my lord, that we have written in the representation, my lord. By hand also we have given,
Oh, acha, it is given, yes.
my lord.
Page 42 has that.
2/7 they have received.
Heard.
I shall convey them to take this matter and dispose of this by next week, Lordship.
Heard. Mr. P. Sundil and counsel for the petitioner. Also heard. Ms. M. Bhattacharjee, Leonard, additional senior government advocate for respondent numbers.
I am for appearing for 2 and 3, Lordship.
For 2 and 3, and Mr. S. Datta. Leonard, Study counsel for the Revenue and Disaster Management Department, representing respondent numbers.
For the bank.
Okay, for respondent
bank.
6.
For
Okay,
4
then-
also, Lordship, RM
okay.
Das, actually, he
Advocate
was
for
waiting, Lordship. For 4 also, RM Das was here, Lordship. I just don't know where he is now.
Okay, RM Das for
Yes,
respondent number?
Respondent number 4, Lordship.
4.
He was also
And
here.
Mr. RM Das, Leonard Standing Counsel for respondent number 4. And for revenue, nobody is there.
Revenue, I just don't know whether they have been served copies or not.
Yes, my lord. You have served, my lord.
Okay, then I can appear, Lordship.
Okay. Then from Mrs. Bhattacharjee, Ms. Bhattacharjee, you say 1,
2 and 3, Lordship.
1, 2, 3. For Mr. RM Das, Standing Counsel. For 5 and 6, it will be You are only for 6?
Only for 5.
Only for 5, okay, for 5. Next one. In the Jamavandi, where is your name?
My lord, at page vernacular as page 34, my lord. And regarding the mortgage, my lord, at next page, my lord.
The in brief form, the case of the petitioner is that by virtue of purchase and possession, his name has been entered in the land revenue records within bracket Jamavandi in respect of one bigger 19 lectures of land covered by the Act number 67.
It's written 4 bigger.
Something wrong? Something wrong? It doesn't match. Paragraph 3 and your statement and Jamavandi doesn't match.
Lord, it's 2 bigger 4 lectures in the Jamavandi, it's written, my lord. 2 bigger
Jamavandi
8
is
lectures.
one bigger 19 lectures.
No, my lord.
And in your statement, you have three bighas. You can't be protected for other land.
My lord, this because this includes two dark numbers, my lord.
We don't know. We are asked you
My
the
lord,
document. You are
my
showing us a document.
notice has been issued with regard to only 67, my lord, dark number.
You see 1 bigger 19 inches of diagram of 167. For the claiming right of a other land which is covered by Dag number 260. Most of the land covered by Dag number 260 is not the subject matter of this petition. The petitioner is in receipt of copy of order number SLR 0.05 oblique Miss MISC oblique 2026-27. This is page 41, dated 29/6/2026. By virtue of which, in exercise of power under section 30, you get it from page 41. I have pencil marked it. Section so and so, section so and so of the Disaster Management Act, 2005, the petitioner was directed to number 123. Accordingly, referring to the said order dated 29/6/2026, the petitioner has submitted. The learned counsel for the petitioner has submitted that the petitioner has been given only 7 days time from the date of issuance of notice to remove, to demolish and remove his house. To stop. It has been submitted that on receipt of the said eviction, the said demolition notice, the petitioner has submitted a representation dated 2/7/2026 to the district commissioner, chairman, DDMA, Sonitpur, Tejpur, which was served in the office of the circle officer occasionally revenue circle on 2/7/2026, and the representation was sent to the district commissioner by speed post with AD on 2/7/2026, and as per the postal track report, the same was served on the in the office of the district magistrate, Sonitpur, Tejpur, on 4/7/2026. It is submitted that till date, the said representation has not been disposed of. It is further submitted that the land being a pata land, the petitioner cannot be deprived of his property in view of protection granted under Article 300A, capital A of the Constitution of India. And that the government would have to acquire the land by following due process of law.
Yes.
Okay? Next part. Per contract, the learned additional senior government advocate has submitted that Acha, before that, you also see, it is also submitted that the petitioner has constructed the house by taking loan from which bank?
Punjab National Bank.
From Punjab National Bank, which is rated as response number 5.
What would be the respect of Punjab National Bank is the guarantor.
But property have been
Punjab
mortgaged.
National Bank is the guarantor in respect of a loan taken by somebody else.
Someone else, not this, not for this house.
Not his.
But this property has been mortgaged for that loan.
Property, not his.
Okay.
But wherein he stands as
Acha, okay,
guarantor.
it's corrected. You see that he has offered the land as security for a different loan. Where the petitioner stood as a guarantor.
Yeah.
Okay. For contrary, the learned additional senior government advocate has submitted that the impugn notice had to be issued because the river had changed. No, because the construction of the petitioner is likely to obstruct the natural flow of water. And the construction has substantially reduced the carrying capacity of the river. And therefore, there are aggravated flood risk during monsoon season, which poses threat to the public safety, life and property, and accordingly, comment is submitted that the District Disaster Management Authority has the power and authority to issue such notice so that the constructions, which is impeding the carrying capacity of the river is made free to so as to increase the carrying capacity of the river and to mitigate damages to life and property during ensuing monsoon season. Next paragraph. In view of the nature of dispute raised and further considering that the petitioner on receipt of notice dated 29/6/2026 had promptly submitted a representation on 2/7/2026, it would be appropriate to dispose of the writ petition by directing the district commissioner cum chairman, district disaster management authority, Sonitpur, Tejpur, to fix to intimate the petitioner about the date fixed for hearing, and on the said date the petition should be heard, and thereafter the appropriate order be passed and communicated to the petitioner before taking any steps. Next para. Accordingly, the petitioner is directed to produce a certified copy of the order before the district commissioner, cum chairman, district disaster management authority, Sonitpur, Tejpur, and also provide his mobile number or email address, if any, to which the further communication about the date fixed for hearing can be communicated, and orders, if any, passed thereafter, be also communicated. Next paragraph. The learned additional senior government advocate has submitted that she would communicate the order of the court to the state authority so that they can expeditiously fix a date for hearings. The same is permitted. Next, accordingly, the writ petition stands disposed of at the motion stage without issuance or notice on the respondents by directing the district commissioner chairman, district disaster management authority on Sonitpur, Tejpur to fix a date for to intimate the petitioner about the date fixed for hearing. And thereafter pass an appropriate order. But I've said it that he will furnish a certified copy of the order. You say that within 3 working days from the date of the order, 3 working days would be 10, 13 and 14. So by 14th you give them a representation and then they will fix a date for hearing.
Only one thing, my lord,
And
in the notice, my lord, there is no mention of any dark numbers, my lord. So in the notice, my lord, which has been served, my lord, there is no mention of dark number. It is not stated that, my lord, 260 is excluded, my lord. Only name of the person is there, my lord.
In
But
your
you are-
lordship,
but-
this will, everything will come
that
up in
will-
the
my-
hearing, lordship. And one more thing, his participation has to be ensured. Otherwise, after notice,
obviously.
they may delay lordship.
We have given you an alternative way of service. If you
Lordship.
don't appear on the date, you proceed with the hearing.
Lordship.
Uh,
This has to be lordship indicated in the
no, but
order.
you
lordship.
see, there's a mismatch. You see, the reason is why we are making a mention of that
My-
dark number
My lord,
is very specific. We asked you, you said it is only dark number so and so.
my lord.
If admittedly on the face of record, if there is an excess land in your possession
My lord.
and it is encroaching on the
lord, obviously, my lord.
of the river,
Whatever,
what
my
is
lord, I have
wrong?
purchased, my lord, that is.
Photograph, lordship,
will
in my,
all
it is
come
not
in
so
the
visible,
hearing.
lordship, but I think lordships, this will be there in colored photograph, lordship main page 37. These are under the building only, lordship may kindly peruse. If it is.
We don't know about
Come,
this.
my-
You see, these are very, these are things which unless we know the site by,
Lordship,
by
physical
by site is very
verification.
My
difficult.
lord, it's difficult, my lord, for the-
Anyway, lordship, he doesn't, if he doesn't participate, lordship, this will,
That's how it-
without his absence.
Oh, yes, my lord.
Because you see, page 39, we have given only 67. The other land you are not,
Yes, my lord, this map has been furnished, my lord, by them, my lord.
we understand, but
My lord.
you see, you have
But in
given
the
only
notice,
one.
my lord, they have not stated anything, my lord.
But second
But-
dark you are not disclosing.
My lord. This is the map, my lord, provided by the Revenue and Disaster Management, my lord, department, my lord. But in the, whatever, my lord, this will come.
Annexure
Whatever
4
portion is, my lord.
Government land, lordship. Annexure 4 is government land. Page 40.
Which government land? You know, government land, my lord. 67. Whatever, my lord, only exercise is to be done to, my lord, if which portion of the land, if it obstructs, my lord, the drain or stream, whatever, my lord, that has to be, my lord, taken care of, my lord. And before that, my lord, survey has to be done, my lord.
In the second, third paragraph, we have said typical land covered by dark number so and so. Then you modify that and say that he has a plot of land partly covered by dark number 67 and partly covered by dark number 260 of village Medhi, MEDHI, Medhi Chuburi, CHUBURI, under the casually revenue circle. That's all. Requisition disposed of.
Item 24 timing.
Much obliged.
Deeply obliged.
Lordship, I have furnished one email, Lordship. Lordship, I kindly see it was communicated to him on 19th of June at 2 p.m. Lordship. Lordship, I kindly see the attachment below. That is the annex copy next. And one minute is also there, Lordship. It is dated 19/6 to 2026. All these paragraphs, Lordship, pertains to the complaint or representation raised by the petitioner. Lord.
This does not address the issue raised by him.
Lordship, I kindly see the minutes, Lordship. In the first portion, Lordship, his rejection, Lordship. In the second portion, Lordship,
There is no minutes here. There are
one minute is dated 19.
Oh, acha.
What was attack it was?
Yes. Yeah, I'll examine and pass over this. You've given a copy to.
Yes, my lord, my lord, in respect of my lord, non-maintenance of the highway work, which is the reason for my rejection of the technical bid. Torsi, kindly turn to page 305 and 306 of my writ petition, my lord. These are the bills prepared by the concerned assistant executive engineer in respect of the two job numbers, which according to respondent number 2, I have not maintained. Page 305, the bills were prepared on 1/7/2026. If I do not carry out the maintenance work, why these bills are prepared, my lord? And for non-maintenance work, if the bills are prepared, then why no disciplinary action has been initiated against this gentleman, my lord?
That reply is there in the reply itself, in 19.6.
My lord, these bills were prepared on 1/7, my lord. 1/7 comes after 19.6. And my lord, one more point, my lord, in a minute, just handed over to me by my respected senior, my lord. In respect of the allegation brought against the Messrs. MP Agarwal in respect of concealment of two numbers of works. The chief engineer sought clarification from respondent number 4. And accordingly, the respondent number 4 submitted its clarification by letter dated 18/6/2026. That per paragraph number 3 from bottom, my lord.
Yes.
Stating that the omission was neither deliberate nor intended to suppress any material information or secure any undue advantage in the bidding process. That means he admits that, my lord, he has suppressed the two numbers of works, my lord. Thereafter, the next paragraph, my lord. The BEC examined the clarification and reassessed the bidder's available bid capacity after taking into account two works referred to in the representation. It was observed that even after inclusion of the said works, the recalculated bid capacity of so-and-so remains approximately rupees 3304.28 crore, which is substantially higher than a minimum required bid capacity of rupees 57.41. Under what authority, under what clause of the tender document the chief engineer has taken this action, my lord? Let the chief engineer show from the provisions of the tender agreement, tender documents, that he is empowered to do this, my lord. My lord, when the matter called up earlier, my lord, I referred to a judgment passed by the division bench of this honorable court, my lord. Kindly peruse the same, my lord. What stand they have taken in that case, my lord? At paragraph 10. Similar argument was advanced on behalf of the petitioner by us, my lord, that even we do not calculate those work, we meet the bid capacity. Paragraph 10. What stand the respondent number 2 had taken? May I read, my lord? The claim of the company, this is the petitioner here, my lord, has been contested by the appellant Sanjay Kumar Singh, the private party in the state of Assam, who were added as respondents to the petition, contending that as per the terms and conditions of the contract, the company was required to disclose all ongoing commitments, including the pending existing works, in the name of its director, Mohammad Matlebuddin. It has been contended that while providing the details of eligible project in the bid, the company had relied upon a work undertaken and concluded by its director, and therefore, as per clause 2.2.1 of the bid document, the company was required to disclose all the ongoing commitments in the name of Director Matlebuddin Ahmed for a purpose of demonstrating its bid capacity. It is further contended that by not disclosing the ongoing commitments, particularly the works pending in the PWD border roads, in the name of Director so-and-so, the company violated a condition of so-and-so, which speaks about misrepresentation on the part of the bidder. This was the stand taken by the respondent number 2. And a completely separate stand has been taken in an instant case, my lord. There is no provision in the tender clause empowers the chief engineer to reevaluate the bid capacity, my lord, after sought for clarification, my lord. Why two separate stand has been taken, my lord? This reflects, my lord, malafide exercise of power on the part of the respondent number 2, my lord.
Yes. That remains the same, Lord.
And my lord, a minute of the financial bid evaluation committee is necessary, my lord. No, on technical bit, good financial.
Those are not the last come to the other. Lordship, facts remains. Lordship, I'm again relying upon page 58, 411. 34.3 B. Lordship, only if such suppression has the effect of influencing the bidding process, then it will be considered as fraudulent practice, Lordship. That is not the situation here. That is one, Lordship. Secondly, Lordship, in that case, relied upon by my friend, Lordship, therein also, Lordship, petitioner was in a position, he had a probability, in case the L1 bidder's tender is cancelled, he had the probability of getting the contract. That is not the situation here, Lordship.
You are referring to which page?
Lordship, page 58, Lordship, 4.11.
4.11.
Then if Lordship comes to page 78, 34.3 B. 34.3 B, Lordship, may kindly see the last few words, in order to influence the bidding process. That is there. And third, the second submission remains, Lordship. Even if this tender process is cancelled, Lordship, in respect of R4, Lordship, he has no probability of getting the contract or entering the contract.
Well, my prayer is to reevaluate my technical bid, my lord. If they assign some other reasons, valid reasons, my lord, rejecting my technical bid, then there is no prayer for me to award the contract in favor of me, my lord.
And Lordship may also see, Lordship, now this copy has was forwarded to him on 19 itself, Lordship. He is saying that it has not been received. But if he has any grievance, Lordship, we will have to silence this order, this decision, Lord.
President, also.
Lordship, I am referring to 123.
Good.
Mark portion now.
Covered it or keen, I think I had it.
So this for 4.
This is the private respondent, my lord, the notice has to
This
go.
L1 bidder law.
He is evaluated as the L1 bidder, my lord.
Okay. So you have for 5 and 6. 5, 6, 7.
Obliged.
Deeply obliged.
26.
By the time I pass orders, it will be, you'll
My
have to
lord.
get it tomorrow.
My lord,
It may not be uploaded today.
my lord. Deeply obliged. Ali, do you want an order to collect one problem?
Appeal under order 43 rule 1B, Lordship, against the rejection of my application filed under order 9 rule 13, Lordship. The order, because impugn order is at page 37, Lordship. Basically, it is without assigning any reason. My application was dismissed, Lordship. And thereafter, so far as service of summons, and on the basis of my application, delay was also condoned. And the other side has not objected to this petition also. In such circumstances, Lordship, this is tenable.
But Mr. U. Datta, learned counsel for the appellant. Next, by filing this appeal under order 43, rule 1 within bracket small d, CPC, the appellant, who is the defendant in the in TS number 51 of 2022, has assailed the order dated 23 6/2026, passed by the learned civil judge within bracket senior division bracket close Kamrup, Amingaon in Misje case number 455 of 2025, by which the petition filed by the appellant under Order 9, Rule 13, CPC, for setting aside the ex parte judgment and decree dated 11/8/2023 was rejected. Next, issue notice. Returnable honor. Give a date after 4 weeks.
Lordship, there is a IF for, because execution proceeding is pending, Lordship. First ever execution.
The appellant shall take steps within 2 working days for service of notice on the respondent by speed post to the D. Next para, list so. There is an IA. Heard Mr. Yudhakar and counsel for the second. Next para.
Title is execution case number 9 of 23.
Second is the appellant in the connected FAO 46 of 2026, by which the order dated same thing, order dated so and so has been assailed. Next para. The learned counsel for the applicant has submitted that in the meantime, the title execution case number 9 of 2023, which has been registered pursuant to judgment and decree dated 11/8/2023, has been is likely to proceed. Next para. The order dated 23/6/2026, which is included in the connected appeal, is reproduced below. This is page 34 of that IA.
Yes.
Next para. From the hearing before quoted order dated 23/6/2026, the court does not find any reason assigned by the learned by the learned civil judge senior division Kamrup Amingaon assigned for refusing to set aside the ex parte judgment and decree. Most of the said order appears to be a total non-speaking order. Therefore, the court is of the considered opinion that in the event the execution proceedings is not stayed, the applicant would suffer more injustice. Stop. Next para accordingly, the further proceedings of title execution case number 9 of 2023, which is pending for disposal before the Court of Learned Civil Judge within bracket senior division bracket Kamrup at Amingaon, shall remain state. Next para. The applicant shall produce a certified copy of the order before the said learned court to bring the order to the notice of this, of the said learned court. Next para. Issue notice on this application, which is returnable on same date. The applicant shall take steps within 2 working days for service of notice on the opposite party by speed proceed AD, next para list on so and so, along with the connected FAO 46 of 2026. Steps here also. Online.
27.
May I please the lordship? Lordship, the petitioners were arrested on 31/5/26. As of today, they are behind the bar for 40 days, Lordship. Now, Lordship, in this case, Lordship Coordinate Bench has already given interim bail to the main prime accused, Lordship, on the basis of an affidavit sworn by his fiancée that they were in the hotel due to celebration of Eid, Your Lordship. And Lordship, by careful perusal of the FIR, Lordship can find out that Lordship, his fiancée, who is the victim in this case, Lordship, she herself has sworn an affidavit that they were there for just a lunch, Lordship. This itself shows that the FIR is a fishy, Lordship, and misuse of police power, Lordship. Now, Lordship, who are these petitioners, Lordship? They were just there for some coffees, Lordship, and the police arrested them without any interrogation, Lordship. They are languishing behind a bar for Lordship 40 days, Lordship. My humble request, Lordship, they may be given the privilege of bail, Lordship, with any conditions Lordship may impose upon them. Lordship, page 19 is the order of the High Court, Lordship. And in the forwarding report also, Lordship, there is no
Request
interpreting.
before the court and prayer before the court are two different things. Each word carries a meaning. But yes, 40 days.
My lord, but there is sufficient material against them, my lord.
What will be?
You were found in the my lord.
Separately interrogation will
My
not
lord.
be required.
My lord.
You are Ms. A. Hussain.
Yes, Sir Lordship.
And Ms. A. Hussain and counsel for the petitioners, as well as Mr. B. Sharma and APP for the state. Next para. You have the case diary.
My lord, case there is, my lord, case there is.
Pursuant to notice issued earlier, the learned APP is produced the case diary, which discloses sufficient materials against the petitioners of having indulged in act of immoral trafficking. And it also discloses that 2 victims were also recovered during the raid carried out at the concerned hotel, and the investigating officer is of the view that the act was encouraging the purpose of prostitution. Next para. Be there as it may, as the petitioners were arrested on 31/5/2026 and fifty days, you said,
40, Lordship.
40, and 40, they're in custody for last 40 days. Court is of the consider open that for the custodial interrogation of the petitioner may not be required in view of the nature of offense. Accordingly, the court is inclined to release, to direct the petitioners to be released on bail on furnishing on those conditions, three conditions. Bail bond of rupees 20,000 each with one surety of like amount to the satisfaction of the Chief Judicial Magistrate. Which place?
Lordship, Nagaon.
No.
Here one function,
Is
here,
that is returned.
although land fence is there, it was from hotel and no such activities, but here some seizure is there, from the
I
seizure.
understand, that's why we
My-
have recorded your statement.
Ali Ahmed.
28 with 29.
My lord, item 28 is the
Same,
and,
28, 27, 28, 29, same FIR,
Same file.
Here in 29, he was in interim,
In 29 is in.
29, he was in interim.
This is
granted on
clear as
nine-
bail. This is clear as bail. Interim made absolute from the
Yeah, but it-
Your Lordship, by virtue of the same FIR, item 29 came today, otherwise it was fixed on 21st of July. The learned arguing counsel is attestation to the Your Lordship.
okay. You want
28, my lord.
you want his what do you call the interim bail to be made absolute, or you want some other date?
absolutely, absolutely.
Absolute. No, Your Lordship may keep it.
Absolute ko hindi, ha?
Okay, Lordship, will be keep it absolute.
Pardon me,
Your Lordship may keep it absolute.
your name?
FB Chaudhary on behalf of Mr. A. Ahmed.
Please come here to the speaker. I want to hear you.
Your Lordship, I'm appearing on behalf of Mr. A. Ahmed.
Okay,
FB Chaudhary.
SB Chaudhary,
FB Chaudhary.
FB Chaudhary.
My
On
lord,
behalf of Mr.
in this case, my lord, item 29, my objection is there, my lord, he is the main person, my lord, who has taken the girls to the hotel, my lord. He's against him some incriminating matters is there, my lord. Item 29, my lord.
Item 29
Mine.
in
Interim was
28, it
granted.
will be same.
Right.
Your Lordship, his fiancée.
Just.
right.
It will be same.
28, sir.
Regular bail, arrested on 35,
Same day.
35/2026. In this case, who is appearing?
I am appearing, my lord.
Your
AK
name?
Hannan. AK Hannan, my lord.
AK,
Hannan.
write your name, we can't hear you.
My lord, AK Hannan, I am appearing for item number 28.
Your name is not there in the.
Yes, my name has not been.
Just write your name and give it. AK, AK,
Hannan.
Hannan.
Hanan,
Yes, my lord.
KHANNAN.
H, my lord.
Acha, okay.
On behalf of
Appearing on behalf of Mr. S.S. Ahmed, learned counsel for the petitioner on record. Is same bail. And in item 29, it will be SB Chaudhary,
FB Chaudhary.
FB Chaudhary, on behalf of Mr.
A. Ahmed.
A. Ahmed. Here you say that by this application under section 483 of the BNSS, the petitioner was apprehending who has been arrested on 31/5/2026 is paying for bail in connection with page 1, Nogam PS case number so and so, under so and so. Next paragraph, the learned APP has produced the case diary and has posed the prayer for bail on the ground that as per the investigating, as with the investigation carried out so far, the petitioner is the person who was allegedly supplying victims for prostitution purpose, and is stated to be the main accused in the offense committed by the other arrested co-accused. It's the same, since he was arrested on for 31/5 and has spent about 40 days in custody, bail, same.
He was in earlier interim, my lord.
This is interim, this is bail application.
Bail application here also, as due to his marriage, my lord. Marriage ceremony, Patna kind of order dated, my lord, 19/6, my lord.
Okay. Okay. Here the bail bond is 30,000. The interim bail granted, you can say that the interim bail granted on by order dated 19/6/2026 is made absolute on same terms. Okay, application disposed of. Yes, item 30.
My lord, item 30 and item number 4, my lord.
Yes.
4 in the motion column, my lord. We have received the case there, my lord.
Here in the, please worship, here the petitioner is arrested on 9/6/2026.
Intermediate quantity.
21B, my lord. And today is about 30 days, my lord. And from my position, nothing was recovered. Some other position it was recovered, and he has whispered my name, lordship. It is mentioned in the FIR. So from my position, only 40,000 recovered. That is why, lordship, as my name has been whispered, that is why, lordship, I have been implicated and arrested, my lord. Today is about 30 days, my lord. 21B, my lord. Only from the other position, 6 gram contraband was
In
recovered.
43 containers.
My lord.
But it, after weight, lordship, it is about 6.3 grams.
What are we, 43 containers?
45, not from my position, my lord.
Yes.
My lord, CD, my lord, here, 27A also there, my lord, financing. Here, financing, my lord, 27A is there, my lord. And from the present petitioner, my lord, Mobdul Hassan, my lord, from his 40,970 rupees recovered, my lord, from his possession, my lord. And he has failed to explain the source of income, my lord. And one of the co-accused, my lord, Rekibur, arrested accused person, my lord, he said that, my lord, the contravention was purchased from the present petitioner, my lord. Or 30,000 rupees, my lord. And there is a link, my lord, and 40,970 was his from his house, my lord.
And that is why, lordship, it is not only recovery of 40,000 is not financing as per section 27, lordship. As per section 27A, my lord, if it is for punishment for financing illicit traffic and harboring offenders. So, my lord, illicit trafficking, they need to establish, lordship, as per the definition. There is no mention in the forwarding whether he was trafficking anything or what is illicit trafficking, Lordship. Only 40,000 recover my position, and because of that, if not my house, my lord.
And here FSL report is yet to be received, my lord.
Well, as recovery is little bit bigger than small quantity, my lord. That is why this application of 37 is not there, lord.
No, 37.
37 regards
Regards
of 37 is not applicable here in this case, my lord. So already that is why lordship, he is inside the jail for about 1 month, lordship, for this lord. Whereas 60 days is mandatory, my lord. I'm the local person, my lord.
My lord, here my submission is that my lord, section 37, regards of 37 will come, my lord. S27A is there, my lord. But kindly produce 37, my lord. From the my lord, section it reveals, my lord, 27A is there, my lord. Then regards of 37 will come.
It would him. My lord, it has been decided in the year 2022 whether on recovery of intermediate quantity, whether 27A is applicable or not. The Honorable Supreme Court has decided, lordship, in our favor, lordship, if recovery is intermediate quantity, then section applicability of 27A is not there.
I am in item number 4, lordship. I am in item number 4, lordship. So for my case is concerned, lordship, he was arrested after almost 20 days. It was on 9/6, search was made, court inquiry was made. No revelation was made that I was anyway involved. After 20, on 28, I was arrested, and the arrest memo, the grounds of arrest, lordship, at page 18, that during investigation, the accused persons, namely Rekibur Rahman, disclosed the voluntary statement that has been regularly purchasing the narcotic from Mali. I am not a drug dealer, lordship. In 2023, I was a drug addict. Thereafter, when I refused to work as a informer of the police, I have made a specific statement at paragraph 5 of my bail petition, lordship. When I refused, they have imposed 2 cases in 2024. Thereafter, I have totally reformed. I have, even on that day also, I refused to work as an informer after the new police comes. That's why they simply arrested me and put in this case. Lordship, another point is 67 disclosure statement. If we treat it as a 25 or 26, or even 66, 77, 67 NDPS Act, arrest cannot be made. On a disclosure statement, it may be taken as a lead only. After that statement, police has searched my house, nothing has been found. I was no way involved. Simply basing on a statement of a co-accused, I was arrested. I would like to rely on, lordship, 2 judgments, one of Honorable Supreme Court and one of Honorable Coordinate Bench of this High Court, lordship. One is at page 13 of this categorically mentioned, lordship.
My lord, here in item number 4 also, my lord, he is the habitual offender, my lord. Lordship,
No, I have mentioned that part.
Page 18, my lord. Page 18.
I have given that part, lordship. I have disclosed in my bail petition also.
No,
How
page,
I have edited.
Page 18, my lord.
Paragraph 5 of my bail petition is there, lordship, at page 4 of my bail petition, lordship.
Page 18, my lord, para 6, my lord. Para 6, my lord.
I have given a specific statement in that, lordship.
That accused Racing Mali so habitual offender and was previously arrested and forwarded to the honorable court in connection with so.
Na case number kada photo kiti are case number?
I am
Those are of 23 and 24, lordship.
whatever may be.
Whatever, police can say anything, lordship.
In the present case also from the statement also.
I have every right to be reformed myself. I'm admitting, yes, I was a drug addict in 2023, Lordship. A small quantity was found from my position. And thereafter, no case, nothing else, Lordship, after 24. I have completely reformed myself, Lordship.
That is their submission, my lord. From the case there is reduced, my lord, I have submitted case there.
But in my regards, my lord, there is no case, my lord. I'm the first offender as per their statements. It has been to the summary, paragraph now 2021. My lord, in 2020 to 19 SCC, in the paragraph number, it started from paragraph number 21, Lordship.
Pardon me?
In this citation, Lordship, where it is decided that if recovery, not from our position, it is from other position, if it is in intermediate quantity, then applicability of 37 and 20 is not there, Lordship. That in 37, rigors of 37 is not applicable, Lordship. It is decided by the apex court, Lordship. Paragraph number 21. 21 is more relevant, Lordship. Okay, simple. Listen. And as my lord, on the basis of the statement, they were arrested, my lord. So, my lord, it is fully and squarely covered by Tufan Singh, my lord. All the statements are inadmissible when
It is for trial to decide, not for us.
my lord.
That is for the trial court to decide, not for us. We are not referring to any provision, what do you call, anything on merit.
Kindly consider the length of detention, my lord.
This division bench order of the Supreme Court 2022-19 SCC would not be binding precedent. This would be operating contrary to the Tejas bench decision of Supreme Court in the case of Satpal Singh versus State of Punjab, that is 2018 13 SCC 813.
2018?
2018 13 SCC 813 that deals with section 27A and this what you call 27A with reference to 37, and here the anticipatory bail granted was cancelled because of the fact that the court did not take into consideration the rigors of section 37. So impliedly, division bench order in your case would not be applicable.
My lord, apart from this, my submission is that if recovery is 21, recovery is intermediate quantity, my lord.
It is still, you see,
One thing
27A is can be
Just one thing more, Lord. May I add? If you read 27A, Lord, there must be specific words: financing, harboring. Merely police can put any section, Lordship, to make a case bailable to non-bailable. Even some cases, Lordship has the experience making a bailable case registered as a
no,
non-bailable.
that is okay, but you
Here,
see,
but
they have
no allegation. If every line of the FIR even read, Lordship, not a single line that harboring. At the best, 29 may be there, Lordship. At the best.
so we don't know, but this we
But
are not,
27A, there must be some material.
so that is a different thing. That's a question of evidence.
No, no.
But on the principle of law,
Lordship, one thing, if I may subject to correction, Lordship, here, FIR case has to be registered on the basis of allegations made on the FIR, not what comes in the investigation. They may add subsequently. Here, if we read the FIR from line 1 to line end, Lordship, not a single whisper. One receiver was personally charged, 6 grams, 45 vials, 6 grams recovered. Spot interrogation was made. Mafidul, his accused, he named Mafidul that I have purchased it from 30,000. Again, Mafidul was searched and Mafidul was arrested, 40,000 recovered. That is the only allegation in the FIR, Lordship. Taking at par those FIRs, those allegations, it is only 21B and 29, not 27A. For 27A, there must be something, yes, financing, that I have paid the money to Rekibur to purchase. I am indulging those business to purchase and sell. That is not there. The only allegation is that as per the Rekibur, he purchased it from Mofidul by paying rupees 30,000. That is the allegation against. So for me, only that I used to sell, the Rekibur used to purchase drugs from me, that much. That is not 27A, Lordship. 27A is a bigger concept, Lordship. Harboring, giving shelter to the accused, who is a drugs business, or financing. Few cases before, your Lordship has what they use the mastermind. Offender is somebody else. Offense is doing by somebody else behind the screen. Here, notice that it is the open case, Lordship. Entire allegation is open. One body search was made, Rekibur 6 grams recovered, 45 vials. Spot interrogation. He admitted that yes, I have purchased it from Mafidul. House of Mafidul was searched, only 40,000 recovered, no drugs. After 20 days, my house was searched, basing on the statement of the accused, which may be 25 days
because she has sold it.
Lordship.
In her house, no drugs will be found because she has sold it.
No, maybe there, maybe there. That's why I'm saying, Lordship, 29 may be there. At the best, if argument's sake, I admit 29 may be there, Lordship. But not a case of 27A. Police can register anything because they have the power. They can register it, but they cannot register a case which is not in the FIR. If something could have found subsequent to investigation, they could add.
This is something which is damaging the society from everywhere.
No, drug abuse is there, Lordship, that much we are all aware of that part. But whether on an illegal basis, liberty should be curtailed. Here the question of liberty is there, Lordship. Basis of a co-accused which cannot be proved in any court. Under 25, 26, or even 67 after Suphan Singh judgment, Lordship. Statement of co-accused, if anything is found in the CD, yes, something is against me, something has been recovered.
Malak,
It should happen in the
2013
forwarding
SCC page, can I get the page number? 2018-13 SCC?
813.
813. 813.
Satpal Singh, SATPAL. Here the question of liberty is there, Lordship, basing on a statement of a co-accused.
It was high play.
Neither section 30 is applicable here, evidence.
1813 SCC 813.
813 Satpal Singh.
Because to be a evidence under section 30 of Evidence Act, Lordship, it has to be a confessional statement. To be given before a magistrate. Here simply co-accused, uttered name, and we are behind the bar.
Mara kindly consider the length of detention.
It is a clear case where 27A is not applicable, Lordship. The rest is on your Lordship. If anything found, yes, something is in our possession, Lordship will consider it.
With any stringent condition, Malak.
Even after the judgment of Bihan Kumar, all commercial quantity cases, because non-compliance of 47 and 48, all have been released on bail. That is illegal because something law, they are violating the law. 67 statement can be used as a lead. Yes, accused has named some person else. Let a search be made, let a further investigation be made. If anything is found, he should be arrested. But if not,
And what is this case 2212 SCC 633? Why is this being cited?
this is Lordship.
Regarding
This Pullabid Ahmed, Lordship.
66.
Yes.
On the basis that they also.
Para 10, Lordship, it has been held in the terms of Tufan Singh that a confessional statement recorded under 67 and will remain inadmissible in trial of an offence under NDPS Act. In the teeth of aforesaid decision, the arrests made by petitioner NCB on the basis of confession, voluntary statement of the respondents of co-accused cannot form the basis of overturning the impugning orders of releasing them on bail. Same has been followed by Honorable Gauhati High Court, Lordship. In the case of Gogoi Deuri, alias Pallab Deuri, it is also an NDPS case, Lordship. And this is a commercial quantity case, Lordship. The BA 4543/23, Lordship. This is a commercial case quantity, Lordship. This is a case under section 20B2C of NDPS Act. In that case, also at para 13, Lordship, on perusal of the materials available on record, it appears that apart from the statements of co-accused persons recorded under 161 of the CRPC implicating the present petitioner, there is no other material on record connecting the present petitioner with the seized contraband. there are statements of independent witnesses recorded under 161, where they have stated the present petitioner has been indulged in business of illicit drugs, no specific statement has been made by any independent witness linking the present petitioner, which have been recovered from the house of the Kuwait case. Exactly similar to our case, Lordship. We are local persons, Lordship, no chance of any flying risks or anything else there. We will cooperate with the further investigation, Lordship. We are not disputing that those are heroines. Yes, they have tested in their test kits, found preliminary. We are not disputing those parts only. And this is only 6 grams of recovery, Lordship.
And 4 offense. And 4 previous offense.
No, I am admitting that, but Lordship, I have specifically mentioned in my case, Lordship. Specifically mentioned. In 23, I was a drug addict. I was forced by police to work as an informer. When I refused, I was imposed against 2 cases. I am facing those trials, Lordship. I am not denying those. I have specifically mentioned in my disclosure also, Lordship, that yes, I have these 3 cases. But here in this present case, Lordship, after 24, I have no case. I was never indulged in any of this drug business. And I am living a reformed life, Lordship. I am only a 27 years old boy, Lordship. I am returned to the society, mainstream. And I can assure there will be no other case.
That would be valid until he changes the lawyer.
My lord, that is true, my lord.
No, because last 2 years I have no case. I am facing the trial. That's what I am admitting, Lordship.
That is
I am regularly facing those cases, Lordship.
Last chance, Lordship. At least in future, we are not going to do such type of offense. Yeah.
My lord, here investigation is going on, my lord. FSL is yet to be received, my lord.
FSL will come, Lordship. Heroine will come. Definitely, we are also on that part. FSL will come. Yes, it is a heroine.
You are submitting, I am not disturbing it. My lord, here, my humble submission is that, my lord, at this stage, Lordship may not consider their bail prayer, my lord. As regarding the, my lord, decimally, item number 4, my lord, several cases are pending against him, my lord. And item number 30, my lord, from his possession also rupees 40,970 rupees are recovered, my lord. And he has failed to explain the source of, my lord, income, my lord. And Lordship already paid the case there, my lord, from it is there, my lord, sufficient material, sir.
Yeah, President passport.
My lord.
Right. Well, 40,000 maybe in anybody's house, my lord. Can we consider that part, Lordship?
But you'll have to get the case diary only tomorrow.
My lord.
You can have it collected from the.
I will inform the office, man. Then office will collect, man.
My lord, with any stringent condition, madam. Obliged, Lordship.
But have it collected.
Oppose.
But have this case diary collected.
My lord.
Obliged.
My lord, I will like to produce one judgment, my lord. Union of versus Khaliluddin. Khaliluddin, my lord. I will produce later on, my lord. Judgment, my lord.
Which one?
Union of India versus Khaliluddin.
So Francine judgment has been discussed and regarding
What is the citation?
2022 Live Law SC 878.
Live law we won't have. We have to.
My lord, but
You have to give it to us.
My
Live law I don't have.
it does not.
judgment.
Okay, item 31.
Right, please, Your Lordship. The regular bail application, my lord, petitioner was arrested on, my lord, 6/6/2026, and as on date, my lord, 33 days in custody, my lord. Okay, my lord, FIR is at page 15, my lord. Page 15, 1/5, my lord. The allegation, my lord, is that, my lord, use of force letterhead of 1 EM of BTC, my lord. In one place, it was alleged that, my lord, use, and in another place, my lord, it was alleged that, my lord, attempted to use. Moreover, my lord, document has already been checked by police, my lord. Give me a second.
Yes, sir.
You have the case diary?
My lordship, we have the case diary, my lord. As per the case diary, my lord, he is a, my lord, contractor, my lord. He has forged, my lord, signature of the executive member BTC and prepared a, my lord, the work order copy, wherein, my lord, some other contractors were given the work orders, my lord. While the documents came up for verification, my lord, he was caught, my lord. These are the allegations against him. And the and the person against whom, my lord, that work order has been issued, my lord, he has also given his statement that this person came to him, showed the work order, my lord. But he didn't believe him and he informed the office, my lord. Statement is there, my lord. And that the letterhead also, my lord, seized, my lord.
Basically, then, okay.
That's all.
Okay.
And along with him, my lord, there are two other co-accused, my lord. They have also implicated this petitioner. Their statement are also there.
This custodial interrogation may not be required. He was arrested on
Six,
Around 6, my lord.
6. 1 month has gone.
33 days, my lord, and everything has been changed, my lord. Page 18 is the, my lord, forwarding report, my lord. In the ground of arrest,
There are good grounds to keep you arrested. Because not only you did the forgery, but you also approached the persons for money.
Lodge. Material, sir.
You're releasing him
Lordship.
because of the length of detention, you are releasing him.
Lodge.
There are materials against
Other
him.
materials, sir.
Third, Mr. K. Borwar and counsel for the petitioner and Mr. MP Goswami and the APP for the state by filing this application under section 483 of the NSS for the petitioner, namely so-and-so, was arrested on 6/6/2026, is paying for releasing him on bail in connection with Kokrajhar PS case number 80 of 2026, page 2. Next paragraph. The Honorable APP has produced the case diary, and on perusal of the same, there are sufficient materials against the petitioner of committing forgery and committing forgery by manufacturing forged letterhead of the executive member from our social welfare department, from our BTC. It was used for manufacturing fabricated work orders. Next paragraph. The learned APP has opposed, accordingly, the learned APP has opposed the prayer for bail. Next paragraph, considering that the petitioner was taken into custody on 6/6/2026 and has spent about
33 days, madam. 33, madam.
33 days
On 6.
in custody. The court is of the constitutional opinion that further custodial interrogation of the petitioner may not be necessary. So accordingly, the court is inclined to direct that the petitioner, namely so-and-so, be released on bail. This 25,000 with one surety of like amount to the satisfaction of the
CJM Kokrajhar.
Chief Judicial Magistrate, Kokrajhar. Conditions will be there. Is very done. Application disposed of.
Obliged.
32.
32, my lord. I'm sorry, my lord. PD not yet arrived, my lord. The iOS sent us a communication, my lord, praying for 1 day.
Already.
It came in the vacation, my lord, so.
I understand. What do you buy? We fixed it on Tuesday then.
No.
For Mr. S. J. Sharma and counsel for the petitioner. So Mr. MP Goswami and the APP has submitted that he is in receipt of communication from the IO seeking some more time to produce the case diary.
No.
According to matter stand checked on again. List again on 14/7/2026.
Lordship permission, my lord, let it, can it be on 16th, my lord?
16th.
No, subject.
Okay.
33.
Obliged.
Wait, please, your lordship.
May I interrupt in one thing, Lordship has asked for that judgment in other case, print out. Alia case. 33 minus 30 we have laid down now.
Hmm.
33 in item 33. Charge sheet laid down.
Gauhati case diary.
Charge sheet laid down.
Charge sheet
Charge sheet.
submitted.
Submit.
Even if the charge sheet has been submitted, Your Honor, even if the charge sheet has been submitted, may submit the 3 points which is essential to
Yes.
submit. Yeah. Your Honor, I'm behind the bar from 28/5/26. It is about 44 days.
Hmm?
It is about 44 days. And
But it's fake Indian currency notes.
yeah, after filing the charge sheet, keeping behind the bar is not fruitful, or it will not sort out any type
That
of.
is for the concerned court to now see, once the charge sheet has been submitted. If it is fake Indian currency notes, then you are destroying the economy.
Yes.
Offense against the statement. Page 14 is the matter. The seizure in the forwarding manner.
Yes.
But Mr. S.P. Chitawat, Learned Counsel for the petitioners. Mr. M.P. Goswami, Learned APP, has submitted that he is in receipt of instructions that during the pendency of this bail application, the IO of GRPS case number 112 of 2026, corresponding to GR case number 1982 of 2026, has submitted a charge sheet bearing number.
Bearing number 105/26 dated 30/6/26.
36.
Lordship. Okay.
Accordingly, the matter is closed with liberty to the petitioners to move the jurisdictional court for bail.
34.
Next, it is clarified that the matter has not been examined on merit. 34.
34 minutes. CD. My please, Your Lordship. This is the regular bail application, Your Lordships. Here in this case, I am paying for bail the two accused persons, that is Your Lordships, Ayub Khan and Abhinav Hazarika, arrested on 7/6/2026. As on today, 32 days behind the bar, Your Lordship. As per FIR, Your Lordships, FIR named accused person, Sanjay Kalwar, had hired rented two motorcycle from the complainant's bike rental agency for period of 3 days by submitting photocopy and driving license and identity proof. But after expiry, the said two motorcycle was not returned back. That is the allegation. But as per FIR, can you see FIR page 12? This is the FIR registered Your Lordship 305B and 313. But as per FIR, there is no any mention that this present to petitioner had hired this vehicle, and also not
any allegation against these present petitioners, and even though not FIR named accused person. And accordingly, your lordships has turned 18 forwarding report. 5 person has been arrested, and accordingly, the accused person was arrested before the district and session judge, and accordingly, your lordships, as per forwarding report, Shahrukh Khan has also released on bail, that you find page number 22. I have enclosed. Who accused also released on bail. Page number 24. Shahrukh Khan also released on bail, and this present to accused petitioner was rejected on the basis of nation states. That is the rejection order. And your lordships, page number 19, forwarding report, point number 4. Investigation further reveals that the accused persons Mitu Rajbangshi, Inamul Haq, alias Lucky, FIR named accused person, Kalwar Singh, procured the motorcycle from the complainant or bike rental agency. But here in this, I am praying for bail. There are 2 accused persons who were not hired that 2 motorcycle vehicle from the complainant. But as per FIR, no name mentioned for the accused person.
CD reveals the other, my learned friend has shown the page number 24. Here, one person has been granted, and others their petition has been rejected, saying that the namely Ayub Khan and Abhinav Hazarika are dealing in stolen bikes along with the co-accused. It also appears that so far they have sold 5 numbers of stolen bikes, including the bikes involved in the instant case. Those bikes are yet to be recovered. And from the statements of the other accused, it is very much clear that they have given the bike to those bikes to these petitioners, and they in turn sell it to some person in Shivsagar area. So they are very much involved in the racket, and also their statements are there where they have admitted in any way that সেইভাবে তেওঁলোকে rent নিদিও one line I am reading তেতিয়ালৈকে জনায় যে নতুন এখন বাইক তাত rent নিদিও তেতিয়াহলে আমাৰ বাইকবোৰ তেতিয়াও ঘূৰাই নাপাওঁ সেইভাৱে আমি তেওঁলোকক বাইকবোৰ ৰেন্টত লৈ দিবৰ বাবে বাধ্য হওঁ তাৰ বাবদ আমাক কমিশন হিচাপে 10,000 টকা দিয়ে at least they take the bikes on rent and thereafter they sold it to some other person's and all the accused persons don't be interrogated they are taking the name of all those persons and they are together also in the house
and your lordships, point number 4 clearly stated, your lordships, that incident was happened by one Mitu Rajbangshi, Inamul Haq, Lucky, and FIR named accused person. But I am praying for bail, one of Abhinav Hazarika and one of that Ayub Khan. But as per FIR named accused person who hired these 2 vehicles from the complainant bike rental agency, that all the incident happened by the FIR named accused person. So length of detention 32 days behind the bar, your lordships. Another thing is this, your lordship.
Stealing is a big racket.
Yes, one minute, just one statement.
On the basis of parity ground, your lordship, other co-accused person.
Parity is something we misapplied.
And your lordships, nothing has been found, your lordship. Actual fact is this, your lordships, both the accused person are found in the FIR. One of co-accused Mitu Rajbangshi came to the present rented house, which is situated at Beltola site, and accordingly, on the day of incident, police came, arrested the Mitu Rajbangshi along with 2 accused person without any reason, and accordingly, search was conducted, but nothing has been found from the possession of present 2 accused person. So 32 days behind the bar, as per forwarding report, ground of arrest 4 number point, that another accused person was happened by this incident, as well as FIR clearly mentioned one of Sanjay Kalwar who had this vehicle. And also present petition number 1, who is a journalist, your lordships, one of Portal Channel. So any condition may be imposed, your lordship. Will cover the investigation as well as in future trial proceeding, your lordships. 32 days behind the bar. Vinod Hazarika, your lordships, is a small businessman, your lordships. Run the said business at the place of Beltola, your lordships. The accused person are not members of the organized crime, your lordships. These are absolutely false and baseless, your lordship. All the incident happened by Sanjay Kulwar. FIR name request.
No, but you are a part of the gang. You're not entitled to be released.
Length of detention shall be considered, your lordship. As per FIR, your lordships, all the incident happened, FIR named this person, Sanjay Kalar, that is clearly mentioned to hide this vehicle, your lordship. As
So
per
you're
FIR.
part of the gang. Case diary reveals materials.
And after submitting his identity proof, FIR named this person, before, as per FIR, your lordships, as per FIR, one of Sanjay Kalwar who had this vehicle. And after submitting his identity proof as well as your lordship driving license.
Gang. There are materials here.
As
showing
point
that you're
number
part of the
4,
gang.
for a moment you see your lordships, 19 page, your lordships. Forwarding
That you
report.
are not satisfied.
That Mithu Rajbangshi and Lucky are FIR named Ekvish person Kalwar Singh, who procured the bicycle from rental agency. But herein I am paying for bail here of Vinov and another.
They are also
item.
part of the gang.
So
No, sorry.
any condition may be imposed, your lordships. And another other Ekvish
Become a
person,
big menace in
religion
the
bail, your
city.
lordships. 32
Heard
is where.
Mr. S. Islam, learned counsel for the petitioners, and Mr. MP Goswami and APP for the state. Expert. By filing this application under section 483 of the BNSS, among the petitioners, namely so-and-so, were arrested on 7/6/2026 in connection with Officer PS case number, page 184 of 2026, under section so-and-so, paying for bail. Next, the learned APP has produced the case diary and has opposed the pair for bail. Next, on the page of the case diary, comment. The investigation carried out so far reveals some nexus between the petitioners and the persons who have taken the motorcycles on rent, which had gone missing with the GPS of installed in both the motorcycles being disabled. Next paragraph. Therefore, the case diary paragraph reveals materials against the petitioners of being a part of the gang involved in the interstate theft and disposal of the motorcycles. Accordingly, the court is not inclined to release the petitioners, namely so on bail at this stage of investigation. Stop. Application stands dismissed. The bail what do you call the case diary is returned. Item 35.
Item 35, madam, we have charge sheet later.
Charge sheet.
Charge sheet submitted.
When?
Yes, charge sheet submitted on 29/6/2026. Charge sheet number 14/26.
29/6.
29/6.
Then we close the matter, giving you liberty to move the decision. Heard Mr. S.C. Biswas, learned counsel for the petitioners. Next, Mr. MP Goswami, learned APP has submitted that as per instructions received by him, on 29/6/2026, charge sheet number.
Charge sheet number 14/26 dated 29/6/26.
Has been submitted in connection with Bokolia PS case number 24 of 2026. Next, accordingly, the present bail application stands closed with liberty to the petitioners to move the jurisdictional court for bail. Next, it is made clear that the matter has not been examined on merit. We are sorry, Mr. Biswas.
Yes, madam.
We are sorry that you had to wait for so long because this is not
Anyway, I have to wait if it.
No, not that. When I'm taking up regular bail matters, then they give me a slip and those matters we pass a general order. No, I understand.
Yes.
So
Anyway, madam,
the-
we have
for
enjoyed
those-
the last holiday.
For those cases where charge sheet have been submitted. Normally, I don't,
Lordship,
but today was a vacation day. I forgot about my
I
normal way
also-
of.
And my lord, your lordship has taken so much of pain, whole day, holiday, my lord, still you are working.
No,
I
because
remember once you have worked after 9 o'clock, I told Mr. Poddar, a vacation code.
no, this is because I'm slow.
No, you are not slow.
Yeah, that-
You are very
on-
deep,
on-
every point you are touching.
On that day, I was also there, your lordship, till 9:30. We
Yes.
were there with your lordship.
You have to sign, I have seen you have
Several
signed all the
cases-
orders.
Several cases are coming one by one. That is now the procedures.
I make it a point, but at times it misses.
Yes.
Very difficult to have all the orders signed, but I
Right.
make it a point. They all help me in doing that. Yes, item 36.
Yes, lordship. Item 36, well, it should have been in motion column, well. A POXO matter anyway, well, notice has to go.
Oh, acha.
Maybe issued, yeah.
It's a new matter.
Yes, new matter, well.
Okay. POXO matter. Heard Mr.
A Pator.
A. Pator, learned counsel for the petitioner.
Application, my lordship has once heard this matter, my lord, regarding, my lord, closure of a second appeal. My lord, may be pleased to find the order, my lord. Is that
But this
okay?
was to be ordered for listing on 31st of July.
My lord, what has happened, my lord? In the meantime, the execution proceeding has started and we had been instructed that on coming Tuesday or, my lord, with page 22 of the IA, my lord, the execution proceeding is going on. So, my lord, if my lord, and I am very sorry, my lord, at this fake and I am troubling my lordships, my lord.
No, but the
Well-
that second appeal was withdrawn.
My lord, actually, that is the issue, my lord. The issue is that, my lord, there is no any such instruction from the parties, from the
No, you see,
appellants, my lord.
there may not be instructions, but on merit.
My lord, yes, my lord, the
On
same.
merit, you see, when we ask questions, then the times the lawyers say that we withdraw the matter. Because the fact that you see come to the issue.
Oh, yes, my lord, we have gone through, my lord, the merit
on the
regarding,
issue,
my lord.
you don't have a case for second appeal.
My lord, actually, in the first appeal before the learned trial court below, my lord, the issue
You
regarding
see, the
that,
fundamental point is only one.
My
Number
lord.
one,
my lord,
the fundamental point is that when you have purchased a plot of land,
my lord, by the
which
defendant,
arises out of a joint
joint
ownership,
property, joint property.
then you only get the right to have yourself to have the case partitioned,
My lord, my lord.
and that is not what we are saying. Supreme Court in the three-judge bench has laid down that
Yes,
the
yes,
only
my lord.
right you have is to have a partition.
My lord, the partition was there, my lord. There was family partition was there. It was there
That has
among
to
the.
be, you see, that partition unless everybody accepts.
No, my lord, the acceptance was also there because from the record, my lord, if we go by the, my lord, trial court records, my lord, there are two paragraphs, my lord, my lord, back to draw my lordship's attention. My lord, may kindly come, my lord, to page 83, my lord. Paragraph. My lord, may I read the paragraph 10, my lord? That I deny the statement made in paragraph 3 of the complaint filed by the plaintiff inasmuch as the same are not entirely true. I specifically deny that the father of the plaintiff and the defendant numbers 2 to 7 had a plan to erect farmhouse in future in the Schedule A land, and the plaintiff and the defendant numbers 2 to 7 were the co-sharers of the Schedule A land, and after the death of their father and the mother, late Saifuddin Ahmed and late Rukia Begum, I say that during the lifetime of the mother of the plaintiff and the defendant numbers 2 to 7, she gave her no objection in favor of the defendant numbers 2 to 7 to sell her share of land, which is specifically within the knowledge of the plaintiff. And soon after the death of the behavior of the plaintiff towards the defendant numbers 2 to 7 was harsh and often quarrel, without any just cause or reason, and as such it was resolved between them to execute necessary family settlement in respect of the entire plot of land belonging to late Saifuddin Ahmed, and accordingly on 23/8/2010 a family arrangement was executed before the Notary Public Kamrup Metro Guwahati, whereby the existing plots of land were settled
which clearly proves that the defendant numbers 2 to 7 and the plaintiff knowingly did not mention the suit land inasmuch as the same has already been settled by dividing the same into two parts, out of which one part was sold to the defendant number 1 and the other demarcated and partition part was kept for the plaintiff after duly erecting of the boundary wall, distinguishing and separating the share of the plaintiff from the share of the defendant number 2 to 7, and as such the share as then existed does not form the part and parcel of the suit land. So, my lord, there was a family arrangement and notarial agreement was also there, my
You
lord.
see what has
My lord.
happened here.
My lord.
Now you have shown us this.
My lord.
Now it was not a transfer by the legitimate owner.
No, my lord.
It was transferred by an ostensible owner.
Yes.
This is
my
under
lord. Yes,
44 of the Transfer
my lord.
Property
My
Act.
lord.
And that share, they say, was excluded from the family settlement.
No, my
That's
lord.
what you have
The
read.
schedule,
See, if it is, that was excluded and the remaining part was settled between them.
my lord.
Correct.
My lord, we are also not saying that he is not entitled to his share, my lord. He is entitled, but only the area, my lord, which if my lord may, yes, my lord may, just, my lord, I am very sorry, my lord, I am troubling my lordship at this page again, my lord. Page 63, just for a moment, my lord. Paragraph 4.
You have the right to partition. You have got nothing more. No more.
Yes, my lord, right to partition is there, my lord. Now, his property, he is entitled, my lord. We are not disputing, but only thing is that, my lord, we have sold after there is a family arrangement of regarding, my lord, this partition or the property has been partitioned, but not a very strong, my lord, at page 63, paragraph 4, just a small paragraph, my lord.
Please come to this.
My lord.
Page 53.
Yes, my lord.
In a result, the suit of the plaintiff is decreed partially on contest. The plaintiff is entitled to decree for declaration
My lord.
of his joint right title, interest and possession of the suit land. That means his possession never exclusive. He can't be put into the property.
No, my lord, in the result, the suit of the plaintiff is decreed partially on contest.
And joint possession of a sea land. That means you are there and along with you, he is in joint possession.
Yes, sir, that is correct. Now, my lord, the issue is that the which portion he is entitled to, my lord, that has not yet been.
That is only right to partition.
My lord.
That is well settled. You'll have to bring it to the notice of the trial, the court. That it has to be
My lord.
by meets and bounds, it has to be done.
If my lord restores this petition, my lord, we will try to satisfy my lord regarding the issue, whether we can make out a substantial question of law is involved or
It's
not.
not there.
My lord. No, my lord, I have a very limited knowledge on the civil proceeding, my lord. So
No,
even
not that. You will see.
My lord. My lord, and the conduct regarding the, my lord, conduct on the lawyer and the client, my lord, we are not blaming the.
No, it's not that.
My lord, my
Because
lord.
of this question you have to withdraw. So
Yes, my
you
lord.
see, the question is that what right does a person who has purchased a property which is a joint property?
Joint property, that is correct.
His right is, you see, there are not one, but there are Supreme Court judgments which
Yes,
say
my lord.
that person will only have a right to enforce his right over that land and claim partition in meets and bounds.
That is correct, my lord. Now, my lord, here is a case, my lord, that the issues regarding whether the property has been partitioned or not, my lord, our
partition,
our-
your own statement says.
yes, it is partitioned, but the, my lord, the issue is that, my lord, now he is saying that the law of preemption he has been drawn in, my lord, that I should get the, my lord, first priority for taking over the possession of the said land, my lord. So those issues, my lord, can, my lord, examine, my lord, the law of preemption, whether in this situation or circumstances, my lord, under the Islamic law, my lord.
No, right of preemption was never invoked.
No, my lord, it has been said, my lord, that in the plaintiff also, my lord. If we go by the prayer, my lord, plaintiff. My lord, the plaintiff will start from page 60, my lord.
Your prayer is for preemption of the Schedule B land.
My lord.
Prayer of the plaintiff.
My lord, the prayer part,
Directing the defendant of one.
66, my lord.
Correct.
My lord.
Now, where is the finding of the learned
Trial court, my
trial
lord.
court?
Yes, my lord, the finding the judgment title should order. My lord, maybe
That is,
page 37,
yes,
my lord,
37.
my lord.
Now,
The relief granted, my lord.
now, this is issue number 3, page 41.
My lord. Yes, my lord. Justice permission,
That is page 47, yes. Page 47
my lord.
is that the plaintiff has claimed preferential right to purchase the suit file and sold by defendant of so-and-so.
My lord.
As mentioned in cell deed, they have denied the claim.
Sold.
As the defendant has also denied preemption, they have plaintiff on the ground that the defendant and sponsor are absolute owners and is purchased it from them by registered sale deed. As
My
far as the plaintiff able to prove the essential ingredients. Now,
Now it is to be seen whether the plaintiff is able to prove the essential ingredients so as to claim his right of preemption over the suit schedule B land, my lord.
then the finding, effective finding is at page 49.
My lord.
As per the moment law, a person is entitled
Yes,
to
as a
guarantee
person
only
is
makes
entitled to the right of preemption only if he makes the demands required under the law. So, my lord, whether before the sale, what was his conduct, my lord, how he.
There
So, my lord, those things.
is
has not
nothing
been-
there.
My lord,
And this part,
my lord,
you see, this part of the finding,
my lord.
please come to
The present suit, as discussed in the foregoing, the suit land is admittedly an undivided family property, my lord, and the plaintiff being a co-sharer falls in the first category. So, my lord, actually, there was a family arrangement for the partition, my lord. That is, some
Okay.
contradictions are also there, my lord. Exhibits. Have to be admitted, no?
now that was issue number 3,
My lord.
correct?
Yes, my lord.
Please, and 3 is for preemption.
Preemption.
Who is claiming preemption?
My lord. The
Purchaser.
purchaser, my lord.
No,
No,
the
my lord.
seller.
He
The
says
family of
that,
the
my lord,
seller.
the right, he is entitled to the plaintiff says, my lord, in his plaint that he is entitled to the right of preemption, my lord. So he should have got the first priority to purchase the land, my lord.
Correct.
Which has not the
So
opportunity.
that was decreed.
My lord. My lord.
Now come to page 14 of the appellate order,
Yes, sir.
part of the appellate order.
Yes, yes, sir.
Now here you will find the grounds are extracted.
Yes,
6, the issue number 3 has rightly been decided against the plaintiff.
my lord. Has been rightly decided against the plaintiff by the appellate court. It had been held, my lord.
No, this is he is quoting
The grounds, my lord.
grounds.
My lord. So, my lord, may I be permitted, my lord, to bring some more lights, my lord, on the issues, my lord, which has been decided, my lord. My lord, my lord, I am of the impression that, my lord, the first, my lord, if I can satisfy for the restoration, my lord, then we'll
No,
go.
because on merit, if you can,
Merit, my
we will
lord.
definitely
My lord.
accept your contention.
My lord. My lord.
But if that right at request is decided in the negative,
My lord. And the appeal, my lord, has been gone through.
then the only right you can have is
My
to
lord.
have it what you call by as a dint of purchase.
My lord. By the defendant one, my lord.
Yes, because the suit was decreed,
My lord.
but except for this preemptive right. So the plaint is at page
Yes, my lord. page starts at page, my lord, 60. Page number 16, my lord.
So that Imtiaz is the plaintiff.
Yes, yes, Imtiaz is the
He is
plaintiff.
the plaintiff and
Samsul Ahmed is the, my lord, purchaser, the
yes.
he is the defendant number 1, my lord. And the rest are the brothers and sisters, my lord, of this Imtiaz Ahmed, my lord.
So he claims to have information about the sale.
Yes, yes,
And
my lord.
then-
Imtiaz has the information, my lord.
He has the information of sale,
My lord.
therefore, you invoke that preemption.
My lord, that I should have the first option, my lord.
And then this Imtiaz that
Evidence में ना बोले, हाँ?
then now if you read this paragraph 10, which you had earlier shown,
My lord.
the defendant numbers 2 to 7, now they say that the land which was sold has been excluded from the family settlement.
Yes, yes, madam.
Correct.
My lord.
That was sold to defendant number 1.
My lord, may I draw my lordship's attention to one of the important page at page 86, my lord. These are the exhibits, my lord, which the trial court, my lord, learned trial court relied on.
No, this is not the point.
That
You
the-
see,
my
the
lord.
plaintiff has not filed a cross objection.
No, my lord.
The issue of preemption was decided against the plaintiff.
My lord, my lord.
So therefore, you are not permitted to raise that plea for the purpose of the issue of preemption.
My lord.
Now, your case is only to that effect that 2 to 7 were permitted to sell, and they had sold it, and therefore in the partition that is excluded.
My lord, my lord. No, my lord, only thing which I have got the instruction, my lord, from the parties, my lord, that the portion of this land which he is claiming is not the land which he has been, my lord, when the family partition was done, my lord, the portion of the land now which he is claiming, that was not given to him, my lord. That is the issue only left, my lord. Huh?
But that has been excluded.
Paragraph 4, my lord, if you go by page 63, my lord, it will
Once
clear.
you can list it on 13th, it is opening, we'll list it on 13th.
My lord,
You see, the reason is,
my lord.
we'll have to be sure as to what is happening.
Exactly.
Number one, if that land has been excluded, then that is something which you have accepted
Yes.
by the family partition.
My lord.
That cannot be reopened in the collateral proceedings.
Correct, my lord.
Correct. This would be a collateral
Yes,
proceeding
ma'am, I
because
have-
that
I-
is not
I have
there.
understood.
You don't have a counterclaim.
My lord.
You don't have a counterclaim. Now that was decreed excluding that right of preemption.
My lord.
So once that is there and you have excluded that part, then nothing remains for you to
Again hesitate, ma'am.
again agitate.
I can understand, my lord. But now they are saying that west side he is entitled, but he is
No, I
claiming some
understand, but
other
that's
side.
not the point involved here.
That is the issue, my lord. That is the issue.
That is why perhaps
Perhaps, my lord, that
at
thing
at
happens.
times when we ask this question,
No, my lord,
I thought that he would withdraw the.
no, my lord, and even, my lord, when I take up the brief, my lord, I saw the name of very
No,
veterans.
that's okay.
My
That's
lord.
immaterial.
That's why, my
That
lord.
is immaterial.
My lord, my lord.
If there's no instructions, there is no instructions. The
My
name
lord.
doesn't matter.
My lord. Or
But the
it can
fact
be.
is that with this question,
My lord.
we did not find an answer.
That is correct. No, my lord, my lordship knows in a civil cases, my lord, my knowledge is very limited, my lord, and
We all have limited knowledge.
my lord, but to argue before my lordships, it is very, I know,
No,
my
my
lord.
lord, that you are humble, but
My lord.
the fact remains that
My lord,
uh,
that instruction I can obtain, my lord. You know.
because when it is case of withdrawal, the
Yes.
query was why would that withdrawal happen?
My lord.
Then on merit, we found that this is the roadblock.
Maybe.
So for a second appeal to be admitted would be a difficult task.
My lord.
So withdrawal means that the issue is open.
Correct.
You can agitate if you have otherwise right.
My lord.
So that's what. Okay. As it is already 5:15 p.m. Though Mr. Here we are on a senior counsel assisted by Mr.
NZ Chaudhary.
NZ Chaudhary, present for hearing of the matter. But the paucity of time matter could not be taken up today. List again of 13/7/2020.
Highly obliged, deeply obliged.
If you can overcome that, you can make a point.
Fine. I will take, my lord, I will make a flow chart. Actually, what is the ground position we are in, my lord? A diagram will help, my lord.
I don't know.
My lord.
Everybody has a different view of presentation.
My lord. My lord. Obliged, please come.